to IPOA at Nairobi, and IPOA could only do so much. I don't know whether he may be having information about it, but it's not like they were not very successful in their investigations. So somebody advised them to approach the Law Society of Kenya. And the Law Society of Kenya, in their act, I think section 4 of their act, it has given them powers to assist government and the courts in the administration of justice. And the LSK appointed an advocate to look into that matter. His name is Oraha, if I remember. Oraha identified some witnesses who actually saw those two young men being arrested. He investigated that matter. That advocate investigated that matter, identified some witnesses, and recorded their statements. And then he approached the Witness Protection Agency to protect those witnesses so that they can now file a petition for habeas corpus at the High Court at Nairobi. And he brought to us 4 witnesses who are very credible. And we were able to protect those witnesses. The LSK filed that petition. They sued the Attorney General as the first respondent, the ODPP as the second respondent, and the Inspector General of Police as the third respondent. Briefly, the outcome was the habeas corpus didn't succeed because there was no evidence that at that particular point the 2 missing persons were in the custody of the police. But Justice Mureithi ruled that there can be some other forms of relief. One is compensation to the families, and they were awarded 5 million shillings each, and then an order to compel the Inspector General of Police to investigate how those people disappeared and who can be held responsible, and also to compel the ODPP to be seized of their constitutional mandate to prosecute in the event that a criminal issue arose within those circumstances. So my take is that one can be an avenue that can be used here in the event that we have cases where we have witnesses. The challenge we get sometimes is that the people who are the alleged perpetrators of those enforced disappearances are state actors. They blame the police, they blame special forces and things like that. So sometimes witnesses would find it challenging to come to Witness Protection Agency because maybe we are also a state actor. But the confidence I would wish to convey here is that in as much as we are a government agency, we carry out our duties independently. And that petition, which was it was petition number 311 of 2016, is testimony to the fact that we can protect witnesses even where they have evidence that is adverse to government officials or institutions. I mean, that's it.
Okay, thank you very much. Kevin, I know you work for IMLU, but also you work for other institutions that have a huge mandate with regards to the issues of EJEs and EDs. Please.
Good morning, everybody. My name is Kevin Muangi. As I've been stated, I work with the African Commission on Human and People's Rights, where I sit in a working group that works on the death penalty, enforced disappearances, and extrajudicial killings. So what we do in that working group is that we monitor the 3 cadets, death penalty, enforced disappearances, and the death and extrajudicial killings, and see the situation as it is in 55 countries. We are guided by the African Charter, and then produce reports on its ramifications. We also set up a database in which we use evidence-based data to do our interventions. And thirdly is that we conduct studies to see whether the situation is actually happening and what would be the recommendations. In fact, currently we are conducting a study on extrajudicial killings and the use of force by security agencies in the 55 countries. I also work with the Independent Medical Legal Unit, which is an institution that works on torture and related violations. That's where enforced disappearances and extrajudicial killings come into play.
So what is your experience in terms of handling the issues of EJEs and EDs in Kenya, specifically working from that very high level, the African Commission?
Enforced disappearances, in fact, it was only in 2018 when Africa now came together to recognize enforced disappearances, because we have a lot of data internally, but we never speak about it. And so in 2018, the working group is when it expanded to form enforced disappearances. And currently we are drafting the first guidelines for Africa when it comes to enforced disappearances. In Kenya, unless you go under habeas corpus, and it's not really a thing that has redress and recourse in law, basically. You have to circumvent it to get redress. And you'll find that unless, the way it usually happens, it is people who are not in uniform. So I'll say it's a police officer, but then how do you prove it? And you'll find in most cases, like he had said, the IG will be summoned, they will say it's the KDF that will be summoned, etc. It's different security agencies, and they'll produce reports and say, we don't have this person, and the court will ask. So clearly you can see, yes, clearly you can see they don't have the particular person, so there's not much recourse I can give. The court will say there's not much recourse. In terms of the extrajudicial killings, we have seen a lot of traction since the 2010 Constitution and the forming of IPOA. We have seen about 8 cases, if I'm not wrong, where convictions have been given out. And even in inquest, when we go through the inquest way, we have also seen that the courts are now saying that some people be charged, the particular individual perpetrators be charged. But we still have a long way to go, because you'll find that the Ransley Task Force gave out specific recommendations on accountability mechanisms, and we are glad that things like the ODPP, IPOA have been formed. But then there's still a lot to be done in terms of forensic documentation, because you'll find the National Coroner Service Act, which was supposed to come in and ensure that there's credibility in how forensics is conducted, is yet to be formed. You'll find that IPOA, and they'll speak for themselves, they don't have a forensic lab per se. And so at the end of the day, if they need a bullet analyzed, they'll still have to go back to the DCI for that analysis. So if they're supposed to be independent, how independent are they, as the discussions we had yesterday? Clearly they're not. So we have done something, but we have a long way to go in terms of accountability.
Thank you, Kevin. Bwana Rashid, IPOA has a huge mandate on this discussion of EJEs and EDs. And one of the things that Kevin has also mentioned is the whole issue of operationalization of the Coroner's Act. What is the problem, and what is your mandate with regards to the subject matter?
All protocols observed. Good morning. My name is Rashid Ngolo Wekesa. I'm the Regional Coordinator, Independent Policing Oversight Authority, Coastal Region. Just before I react to the question, I will want to talk about our mandate area, maybe so that we align. Our mandate area is in giving effect to Article 244 of the Constitution, which seeks to enhance professionalism of the NPS in terms of accountability in their work to the members of public. And we also conduct investigations into extrajudicial killings and cases like enforced disappearance. We also investigate police misconduct. We conduct inspections of police premises, and when you talk about premises, we are talking about also the cells. And we look at whether those cells are meeting international set standards, and we also look at the turnaround of taking suspects to processing the suspects through the due process. We also monitor police operations. Any police operations, IPOA will have to monitor to see how police conduct themselves. And we also review files by IAU. IAU is an internal affairs unit. They investigate cases, but we are mandated to review their files to see how impartial they were, or if there is any complaint from any of the members, then we can be able to review. Now, talking about a matter that my friend has talked about, indeed, we do not have some of these facilities, and so it's a challenge area that we're still working on. We hope that soon, maybe with much intervention, we will be able to overcome. If I can be able to be brief as that.
Yeah, but I had asked a question about operationalization of the Coroner's Act in your interaction with these laws. What exactly, where is the problem? Why don't we have the Coroner's Act being operationalized? Because we need to have, for instance, the coroners in every county and at national level, but this has not happened, and of course it's also impacting on all the conversations that we're having right now. So where is the problem?
Actually, what I can say is IPOA is working hard to make sure that this happens. And right now, as we talk, we have a team that is going around to try to make some amendments that will be able to, or to try and bring up regulations that will be able to help have all this happen across our regions. So it's something that is a work in process. I cannot be able to speak to it very authoritatively.
Okay. Ndugu Hamisi Mwadzogo, I know you've interacted with the courts multiple times. I'm really interested to understand how, or what are some of the avenues and tools that are available for families and victims of extrajudicial killings and enforced disappearances that they can use to ensure that they realize justice within the court system. And what has been your experience this far?
Good morning. Thank you very much, Mr. Rule, for that particular question. And I believe we are together in this particular discussion. We have not been left to discuss alone. The audience is so much awake as we talk of this important subject. Generally, deriving from the question and from the contribution of my fellow panelists, as advocates, we always act upon instructions. We need to be instructed by individuals in the event they have problems. And in this particular issue that we are discussing, the issue of enforced disappearances and extrajudicial killings, the most conservative, let me actually use the particular word, it's what has been said, going to court to try to seek orders of habeas corpus. Generally as a writ that has traditionally been known for those individuals that have been detained or they are in a non-unlawful custody. But generally speaking, as we are sitting today to discuss this particular issue, courts have pronounced themselves in several matters as far as the issue of habeas corpus is concerned. And as you are discussing that, we are coming from the basis of Article 51 as being one of the rights of a person that has been detained, that the person is entitled to be given an order of habeas corpus, an order for him or her to be produced. But generally, if you look at it carefully, we must admit that consistently there has been an institutional and a structural response to majority of the applications of habeas corpus that are being filed. One of the major issues that we are having, it is the fact that majority of the petitions that are being filed, they do lack the factual background. As we go to court today, it is very easy to be told that we are not sure on the persons who did the abduction. We have not provided the identity of these particular persons. You have not told us whether this person is actually in custody or not. So basically speaking, we need to agree. Consistently, if you look at the determinations of the courts in this particular aspect, you realize that there is a common and a structural response to the fact that majority of the petitions do lack the factual background to support its sustenance. The other issue that we have actually said, and I believe that should be the departure of our discussion, the petition by LSK, by Apollo Mboya, it's petition number 382 of 2017. Specifically, that particular petition was a response after realizing that majority of the habeas corpus applications are failing. And if you look at that particular petition, it would actually say it is a progressive mode of trying to tell the courts that as a matter of fact, we have been having several cases of extrajudicial killings. We do have if you look at that particular petition, there were 5 prayers. The first prayer, particular petition, the petitioners were simply asking the court for a declaration to confirm that indeed there has been a widespread and a systematic system in which enforced disappearances and extrajudicial killings are being carried on. That was the first declaration they were seeking. The second declaration they were seeking is the issue now of the Attorney General advising the President to establish a judicial commission of inquiry, specifically under Section 3 of...
later on flushed out.
Yes, yes. So actually that was the second prayer. And then recognizing the fact that we may have a problem with the Judicial Commission of Inquiry, the petitioners also went further to say the establishing legal instrument of that particular commission should actually adhere to the basic principles of the International Convention relating to the civil and political rights, and even the United Nations Convention relating to extra legal apprises, on the effect that we should have, number one, that the investigation should be carried by an independent commission, because majority of these instances, it's the state actors that are alleged to have actually done that. And secondly, they're also talking about protection to the judicial officers and also the councils that will be in that particular commission. They're also talking about having a system of investigation that can be accountable, a system of investigation that the perpetrators can be identified and prosecuted, and lastly, having a system whereby the victims can participate. Basically, that was the petition under 382 of 2017. The determination of that particular petition, again, did not move far away from our that under that particular law, there's nowhere the president can be ordered on how to perform his duties, and it ended there. So basically, what I'm saying is courts where they sit today, I can even make reference to petition number 12 of 2017. It's another important petition of Rama Bintu. In that particular petition, Justice Makau stated that even with the fact that extrajudicial killings and enforced disappearances can be very emotional, but the same should be handled within the ambit of the law. So basically, in our discussion, we're recognizing that the current status that we have may be problematic, but we need now to actually go higher. And maybe in our deliberation, we can discuss more, because when we are talking about a judicial response, it means we need to depart from whatever we are currently doing. So habeas corpus generally is not working as a matter of fact. Let me stop here as we proceed to discuss.
Thank you very much. When I agree, what other opportunities do we have that really help victims of enforced disappearances and extrajudicial killing realize justice? We've noted clearly, from the petitions, from the efforts by the LSK, to have a judicial commission of inquiry set up or put in place. Habeas corpus is not working. What other opportunities do we have through the judiciary or through the courts, if any?
Yeah, thank you. Thank you for that question. When it comes to the issue of judicial response, there are two aspects, starting with extrajudicial executions. There is the issue of criminality, and then there's the issue of now the killings. It has been said that the killings are a response to criminality. And when we have gone under the auspices of the Police Reform Working Group to the communities, we've had community members saying, hapa wezi hata wakishikwa, wakienda kotini, kesho wanaachiliwa. And so what we've been able to observe is a community that does not have trust that the criminal justice system can address criminality. And so when they see the killings take place, they see it as instant justice. And that has informed a lot of the support that we see from the communities for some of these killings. And if you know, in some areas we have officers who are known to be perpetrators of this and who are celebrated in those communities. If you remember 2013, when Katitu was arrested in Githurai, there were demonstrations for 3 days with the community saying, release him. Yeah? And that is the context we're operating in. And that then calls us to look at the criminal justice system. What is the issue? Number one, 2017, the NCAJ did a criminal justice audit, and they identified that the most serious offenses in the criminal justice system are being crowded out by petty offenses. And so the duration of time that it takes to process a case, a serious case, let's say a robbery with violence case, is longer than what it ought to be, because we are busy processing drunk and disorderly, idle and disorderly, all those cases that, we can process through alternative approaches. And then what this does is that we have a judiciary that is heavily clogged, dealing with a lot of backlog, and therefore incapable, to loosely speak, of addressing criminality in a timely manner. Because we have criminals roaming around. Some of them are, engaging in criminality, in repeat criminality when they're out on bail. That should not be happening. Then in 2018, the harmonization of command control happened. And now I'm jumping into enforced disappearances. And, a lot of things also are happening, as Kevin and the team have mentioned, around the accountability, courtesy of IPOA, for police killings. And so what we are seeing now is a trend in which the preferred approach is to disappear these people. And the idea is for them never to be found. And that's because there is a gap in law, and I think it started to come out. 2017 January, a case takes place in Migori. A young man called Daniel Baru is arrested by the police officers. He's in station for 4 days. Then on the 4th day at lunchtime, the wife takes him lunch on a Thursday, and then goes back home. Then on Friday she comes back and the husband is not there. Then when this matter goes to court as a habeas corpus petition, it becomes apparent that the officers, the OCS says this person was released in the morning of Thursday, which is a contradiction to what the wife says. In its final judgment, the court determines that these officers, there were 6 officers in that matter, were responsible for that disappearance, and the court orders that the DPP opens a murder, prosecution against these officers. Just another example of the futility that we have seen with the end product of the habeas corpus petitions. And so that, ended there. I think at ODPP they're trying to see what can be done. But the issue is the law. We do not have a crime in this country of enforced disappearance for which an individual or a small group of people who have engaged in disappearing someone forcibly can be charged in a court of law and convicted and sentenced. We have enforced disappearance under the International Crimes Act, recognizing the Rome Statute, and that requires a threshold of widespread occurrence. So if you disappear many people, we can prosecute you in this country. But if you disappear 1 or 2 or 10 over a period of 2 years, or I think right now the Missing Voices website has about 30 something, if not 60. But, and some of these officers are known, including in the Kawangware case. There are people who know who arrested them. But nothing can be done to them. Because when these bodies have not been found, you cannot prove the fact of death. So if you took a murder charge, how did they die? When did they die? What killed them? You can't prove that. You cannot prove the cause of death, as a result. And so that then becomes an issue. We cannot resort to murder to address cases of enforced disappearances. And what that shows in brief is that we have a situation where there is a gap in law that is allowing for a crime to take place without recourse. And so we need, in very specific terms, we need to criminalize enforced disappearances in Kenya.
Thank you. Kevin, you seem to want to respond or to add some issues there.
My take would now go to the regional and international mechanisms that we have. So Kenya has ratified the International Convention on Protection of All Persons Against Enforced Disappearances. But then it's only signed onto it and refused to ratify it. And so that would be a point where we can start advocacy for Kenya to ratify it. Because one of the things it does, it creates the committee on the enforced disappearances at the UN level, where you can take individual cases at that level. Besides that, there's a working group. So there's a committee and there's a working group on enforced disappearances at the UN level. So for that, you don't need to ratify it. You can write to it and they can ask Kenya to conduct investigations, which is a mechanism I do not think Kenya has used effectively. I'm yet to see a case of enforced disappearance where civil society or individual complaints have written to the committee, to the working group, and asked them to investigate, and asked them to write to Kenya to investigate. That hasn't happened. At the ICCPR, International Covenant on Civil and Political Rights, Kenya has ratified it, and we reported, I think, last year, issues of enforced disappearances were not prominent. So even the recommendations made by those committees were not really heavy on enforced disappearances. Kenya is going up before the United Nations Convention Against Torture in April. Have we submitted a report on enforced disappearances to ensure that the committee reacts to it and Kenya actually implements these recommendations? The African Commission, Kenya is also being reviewed in April, and the Commission is very interested in cases of enforced disappearances because the government will go there and say, Kenya is a beautiful country, we have no issues, nobody's dying, nobody's being enforced. So who will raise these issues? It's me and you, the civil society at that level. And also the African Commission receives complaints. We have seen the OGEC who went through the African Commission as well. If you have exhausted local remedies or you have reason to believe that you cannot receive the remedy you're seeking at the national level. So there are quite some mechanisms that I also think we haven't effectively utilized.
Thank you very much, Kevin. Besides criminalizing enforced disappearances and, of course, ratifying some of the conventions that you've mentioned, I want to come back to you, Bwana Mozogo. What is the way forward? How do we, like I asked before, what are some of the other opportunities that are available for victims of EJEs and EDs through the judicial process? We are saying clearly we need to criminalize enforced disappearances, we need to ratify conventions, habeas corpus is not working. How do we improve judicial response towards this problem? And then later on, I will come back to you, Bwana Wekesa, regarding the SOPs.
Thank you very much for that question. And I think the debate flows from our initial stand. One, habeas corpus problem that we have exist. Gap as stated under Article 51, habeas corpus really came strong with the thinking that in all cases of enforced disappearances, there will be an element of we or the clients or the petitioners knowing where that person is detained. So basically, when you come with a case to a nature that you cannot even explain who are the perpetrators, where that particular person is, generally you're falling short of remedies under habeas corpus. And then secondly, the issue of extrajudicial killings, as explained, we cannot use the existing murder as an offense to try to litigate on issues touching on extrajudicial killings. But again, the attempt by LSK, though the petition was not actually determined on merit, I think this is another avenue that we actually have. The civil society, the LSK, and the practitioners can actually try to come back again, because 2017 to date, things have changed. We can still come back to court under the same thinking of a progressive strategic litigation, trying to say that the conventional methods are not working. Now we are coming with seeking declaration. And the reason that is making me think this particular way, I believe all of us will appreciate that as a country and our courts, we have been having effective assertion of rights. The way the Bill of Rights now is being exercised and the way the courts are responding to issues generally touching human rights, there's been an element of improvement. There are some rights whereby during those particular time you cannot even think or envisage of going to court to demand them, but courts have been so much progressive enough to grant these particular remedies. Again, we should also admit or agree that at a time or as we are progressing, the courts have really tried to have an effective judicial protection of rights. It has been there, yes. Courts have been trying to explore and expand its territory as far as the issue of rights are concerned. But now specifically on this particular issue, and this is what I was saying, when you're talking response, it is not merely an issue of the judiciary acting. What you are saying is, what is that different that can actually be taken? And for this particular Brother Lule, will actually realize that it was a creative petition. Creative in a nature that it was informed by the systematic and institutional failures. So the way it was coached back in 2017, it was smart. it's unfortunate that the petition did not actually go to be determined on merit. It was technically determined on the basis that, Jack, we cannot actually go this far. Okay? So the issue of coaching remedies in that particular petition is just a matter of us recognizing the insufficiency of the available systems. Because he was not calling for a commission of inquiry, he was specifically calling for a judicial commission of inquiry with structures that will actually try to defeat the very cause of fears that we have through the other committees and systems that we have.
Okay. Bwana Rashid and Bwana Karani, as the state agencies dealing with these issues, we know that we have standard operating procedures to deal with gross human rights violations that are committed by the police specifically. How helpful have these standard operating procedures been so far?
Yeah, thank you for that question. IPOA has really done so much. I know that maybe if we are rated with cases that have been concluded in courts, but I would want to register to you that we have done so much because we have so many files that we have been able to submit to ODPP. We have files that are in the process of being submitted, so many of them. But when, of course, what I should be able to say is that we have been able to really conduct investigation into matters of extrajudicial killings because mostly those are issues of interest, especially around the coastal region. Apart from just conducting investigation, we have also engaged in the agency collaboration where we share information. And I think I've really done a lot of sensitization with even URIA, they have been calling us. We have done with the National Police Service. I've also organized, last December, I organized for a meeting where I met all the OCSs within Mombasa County and all sub-county commanders and county commanders. We have been discussing on these issues because we realize that most of these extrajudicial killings are done by young officers who have not been mentored through. And on 16th, I was in Kilifi, I was talking still to sub-county commanders and county commander about this because investigating is quite reactive. But how can we proactively engage so that we can be able to solve this very problem? On issues of enforced disappearance, indeed we have been able to run with such a matters and we have reduced the numbers, if I should say. There's a time when I reported to the coastal region that was around 2020. The numbers were quite high. Of course, they are usually alleged because there are no witnesses to this. And as my friend from Witness Protection said, most of the time enforced disappearance will also come with a lot of fears that go around witnesses thinking they would be attacked, they would be followed and all that. So out of what we have been able to do to try and talk to in a criminal justice system forum where we engage and discuss about what is happening and how we can better help deal with this problem has helped us to be able to deal with the problem to some extent. There is a lot of sharing of information from the human rights defenders who most of the time will come telling us about it because most of our complaints will come from human rights defenders, will come from the members of public, will come from the social media. But sometimes after reports have been made to our end, we do not get witnesses. But after engaging human rights and other state agencies, we are seeing witnesses willing to come and testify, record statements with us So I think we are working towards reducing, if not eradicating it.
Is there like a government policy to forcefully disappear people?
There isn't any policy like that. There isn't, and I don't think it will ever come.
Okay.
Because, of course, you know very well that is against human rights. It is a violation of human rights.
Okay. Ndugu Karani, from the SOPs issue.
For us, for the SOPs, we only collaborate with mostly IPOA, at some extent IJM. When they refer cases to us, which involve police misconduct, to such an extent where we assess and find that the witnesses are in danger, we arrange for immediate evacuation of those witnesses, even sometimes when they have not even recorded their statements, so that even when they are recording their statements, they are already safe. That's the much we do.
Sawa sawa. Thank you very much. I now want to open it out to our on-site audience, as well as the online participants, if any, if they have questions. So questions, comments to the panelists, ladies and gentlemen. Okay, we have first question here, or comment, and then pale nyuma, lingine hapa kwa Tony, then the fourth question there. Feel free to even ask in your mother tongue, it's okay. I'm sure they will understand.
Good morning. My name is Nicholas Ndavera. I think our theme is access to people-centered justice. I'll speak on something concerning the SOPs and the policy concerning the extrajudicial executions and enforced disappearance. You could be a victim. One of your relatives, your wife, your child can be executed as a result of this extrajudicial killing by the police or any security agency. Now, do we have a public policy where if I've lost somebody and I know the police, a particular police is involved, and I'm very sure if I go to the police station, I'll be frustrated. First of all, I may not be able to record the statements properly, or there could be a way of, circumventing the issue. If sometimes you're frustrated, go and come back, record this, go to this officer. So is there a policy where the public can be protected in a way that they are able to report the matters in a way that the matter will not be misdirected? And concerning the SOPs, do we have a standard operating procedure whereby the communicated to the public, whereby the public knows exactly what has happened? Like, for example, you found a body at Yala and you can refer to a particular police station, and this particular police station must be responsible. You go to the OCS, you're frustrated. Do we have a public policy or standard operating procedure where a citizen can go, follow that procedure until the person involved is brought to book, and at the same time?
And finally,
concerning, can we have a recommendation by the Civil Rights Society to expand the mandate of the legislative arm in order to make use of the available organs like the Senate or the Parliament in order to set up committees that can be able to mitigate on the issues that come up?
Thank you very much. At the back there, Uliza swali straight because of time. We also need to move very fast now.
Thank you very much. My question is
Just go ahead, please. Yeah.
My question is just simple. For now, our community down there or in the villages, most of our people don't believe in the system of justice that is happening now, right now in Kenya, mostly in Mombasa. Like the victims now who are found, disappearance of the victim, most of them, they are youth who disappear from different places and different counties. But don't take action as in a very short time, because our parents or the community people don't believe in this system, because it takes long to decide whether these justice will take place or will not take place. They find the body and then they don't find any person or anybody to justify who did this, and the community people say it's the government or it's the police, something like that.
So what is the question?
The question is, why is it taking so long to justify this issue while we know that everything is open and we don't have an investigation open by the community, by the government itself?
Okay. Sawa. Bwana Tony, I think you had raised your hand, but you stepped out. Where are you? Okay. There's another question here. You already have the microphone.
Yes,
Okay.
my name is Jen Onyango. My question goes to Mr. Wekesa. You have talked about the issues of reporting for police in action. How do you ensure as an institution that those complainants who report to your institutions on police in action are not victimized, re-victimized? Because most of the time when you go and report a case of a police in action, there's that fear that that police officer would want to know who is this person that reported us to IPOA. And probably there's that issue of re-victimization. Because I've seen most of your letters, when you do them, you say that we have received complaints from so and so. So how do you ensure that this particular person is protected against re-victimization?
Okay.
And then my other question goes to Mr. Wazogo. You have talked about improving judicial response to extrajudicial killings. And you have talked about decisive judicial response. How do you ensure that a judicial officer makes a judgment that is as per what you expect? Because we all know that judicial officers make decisions based on the law and the evidence that they have been given.
Okay, right here in front of me. And then Esha. Please make sure when you hand over the microphone to the participants, it's already on.
My question is, how accessible are our cells? Because I've heard you saying your mandate is to see that we are working on UN standards when it comes to our cells and everything. How accessible are our cells for persons with different disabilities? Thank you.
Okay. Hakuna swali lingine online. Are there no questions out there? Great. So we will. Oh yeah, sorry, Esha.
Thank you very much. Mine is a question and a comment. There is instances where the public or the justice actors, CSOs, and media raise very high expectations on people who have been victimized or people who have suffered extrajudicial killings and enforced disappearances. I think it is high time for us to ensure that when instances like this happen, we don't raise expectations, knowing that there is a very big gap in our criminal justice system. Let us ensure we take the victims through the due process of law. This is what will happen. This is what will happen until this time. Because when such instances happen, they have so much expectation that justice will be made tomorrow or in a month or in 2 months, when that is not the case. So you find that they now wonder what happens, because now everyone who was on board during the time when maybe a victim, somebody has been found murdered, everyone comes on board, but then they disappear. Maybe immediately after, there is no talk about it in the media again, and people wonder. what is really happening. So raising so much expectations when people do not know how the due process of law works is something that we need to intervene and advise them on what really they should expect in the courts systems. My question now is, why is it so easy for an inquest, for issues like this to be taken as inquests and not the actual criminal elements? Because I know with the state actors, they would want to protect their people in terms of raising inquest proceedings rather than the actual criminal. When pathologists reports, both independent and government pathologists, show that this is actually a murder case, or this is something that has really happened and not, that can really identify who actually took these people. Why is it so easy for them to start inquest proceedings and not otherwise? Thank you very much.
Asante sana. The chairperson MLS, the last question, and then we'll only do one round. And then we get a parting shot, we are done. Okay, sir.
Thank you. I've got 2 questions, and I'll go direct to IPOA. I think it stands for Independent Police Oversight Authority. My first question, is it the case that in the curriculum for training police officers, you train them, or they are trained on violent and extremist means of extracting information the way it used to happen? What is the curriculum? What do you teach these people in training schools? Because the police force has been known for torture and all that. So you cannot be training me to torture, then you expect me to come out there and pretend like I'm a priest in execution of my duties. Number 2, do you people in your role as oversight authority ever visit the cells where people are kept when they are arrested? Are those cells in accordance to the international standards? Do you think there is a call for improvement of conditions in the cells? Because you find 30, 40 people crammed in a room of 10 by 10 without a toilet, locked there the whole night. What is the position on those 2 issues? Thank you.
Thank you very much. Now to our panelists.
Excuse me, we have a question online.
Okay.
From Teresia Buire. She's asking, what is surety of protection of witness of sexual gender-based violence, especially for women human rights defenders?
Okay. Okay, Bwana Agri, I think tumesikia maswali, so we'll start from your end, moving up to Bwana Mwanzogo. Very quickly and direct to the responses.
Thank you. I think there were no questions directly touching on me, but there was an issue around the trust in the system. I believe this is the criminal justice system. And what I'd like to say about that is there's 2 aspects to the issues we are facing around EJE and EDs. Part of it is systemic. The other part is cultural. The systemic is what we need to do around the laws, around harmonizing command control, ensuring that the OCS knows everything that happens in his ward, and if someone is taken or killed in that space, he should be answerable. Those are systemic. But now the cultural aspect of it is where the issues are, because you might put in place the system, but if we have a culture that encourages cover-up, for example, it will be very difficult to extract evidence that can be used in a judicial process for a successful prosecution of a matter. And so the component of culture change is also very critical and very connected to our demand for change when it comes to the criminal justice system. And just to mention, I think there's a question you asked on the National Coroner Services Act. In 2020, at the height of COVID, we had a Zoom engagement. I think Kevin and his team were part of it, in which we put to task the office of the AG on it, and they promised that they're just waiting for the budget because it was a money bill for that to be included. But that has not happened. Maybe we need to see how to follow it up.
2022 now.
I'll go straight to the question about protection of victims of sexual and gender-based violence. We offer a wide range of measures. We start by giving them psychosocial support. We have psychosocial officers who do that. We also extend to them medical support. We pay for their medical bills, and we relocate them to safe houses, to places of safety, pending their testimony in court. Now, during testimony, they are also afforded psychosocial support, especially those ones who have undergone through traumatic experiences, which would compromise their capacity to give evidence. When they relive those moments, they are given psychosocial support in court. We also facilitate them to testify via video link in the event that they are uncomfortable being physically in courtrooms, or we facilitate them to testify in a witness box, which has a screen where the accused person may not be able to see the witness, but the witness is able to see the witness, the accused person. So that's what we do. Sometimes we are also forced to evacuate them from areas of danger, and we take them to places of safety. And you realize such kind of situations, they kind of are a bit tricky, because in some cases they involve families, where maybe you are going to rescue a lady from a violent or abusive husband, but we do have those mechanisms in place to protect them. That's all.
Thank you.
I'll start with the National Coroner Service Act. I know the AG had submitted a request for about 30 million to set up the office, and they're currently in talks to set up the office, the HR components to it, so that the money is adequately given, because you have to justify, I need 30 million to do 1 to 3 things. To go to the question on why investigations take long, I'm a person who plays fair game. So yes, I complain about the police, but at the other side, I also understand them. So the police, the ratio right now is 1 to 1,000. So one police officer is supposed to protect 1,000 Kenyans, and the UN rate is 1 to 450. Secondly, a police station gets around 100,000 to operate. To conduct a murder case costs around 700 bob. And so there's the issue of human resource, there's the issue of resources to it, attached to it. The IG is not a budget holder. The CS for Interior is the budget holder. So it's like you're given your salary, but someone else is budgeting for you. So like Adr has said, there's a lot of systematic things that need to change, police reforms that needs to happen for investigations to be quick. How many pathologists do we have? If I'm supposed to go, if I've done, there are very few. And so if they're required in court, you have to choose which court do I go to give evidence, because you have to adduce the report that you produced. And so we need to be fair and attack the police as well, but also be champions on police reforms. Let them be adequately resourced, and then put them to task on how they're using the resources they've been given.
Thank you, Kevin.
A lot of questions here. And now, when it comes to complaints about death, there is a friend there who talked about, you know, a police officer that is involved and you do not know how to go about. IPOA investigates all complaints against police. I will be giving you our contacts so that you can be able to reach us. You don't need to come to our offices. You can still reach us through email. You can reach us through phone call. And it's very easy. And that will be also addressing Jemima's question of accessibility. Though our offices have, we take our offices in buildings that have elevators. So in issues of disability, you can still be able to access our offices. I don't know whether that answers your question, Jemima. For cells, or prison, of course, I may not be able to answer for prisons because we are limited to police. Unless prisons are involved in maybe policing or something of the kind, that's when we can be able to deal with them. Now, victimization. I changed question on victimization. Most of the time, we look at the kind of complaint that you have brought to us and the amount of threat it can attract. Now, where threat is imminent, we most of the time collaborate with the Witness Protection Agency, and we thank God that we have Robert Karani here who can be able to attest to the fact that we have taken quite a number to them. There are complaints that you bring and complaints that we can reach out to the OCS, verify what the allegations, because we also don't want to kind of demoralize or demotivate the police officers, because we need them. So we want to verify the complaint that you have made to us, and after we do that, we will have to communicate back to you. So when we are communicating, like say to the OCS, we need to tell the OCS that there is this person who has complained. You cannot say that an anonymous person has said something happened. You see, if you are handled by a given station, then your name is in the OB. Therefore, the OCS will be looking at the OB vis-a-vis what we are reporting, and will be able to deal with the matter. If it's a matter that was maybe in action, we will just seek status update of how the matter is progressing. But if it is misconduct, we will conduct investigations, because we also have guidelines on what we need to investigate, what we need to maybe send to IAU, and what we need to also have the police station investigate. So in matters of victimization, we really take care of that, and we don't expose. There are matters that you would report to us and we treat as anonymous, and we will not expose you at all. In informing the victim on the progress of our investigations, I think this was asked by Aisha Mohammed. We most of the time inform the complainant of the progress we are making. Immediately we commence investigations, we will get in contact, we ask the investigator to get in contact with the complainant and inform the complainant of the progress of the matter. When the file has moved to ODPP, we inform the complainant that the file has moved to ODPP, because that is an independent institution, and we will not be going to ODPP to tell the ODPP to fast track. We want ODPP to do their work so that when they make recommendations, we can be able to, but we make sure that we inform. And in any case, usually members of the public have my number. within the coastal region, members of the public have my number because I've been sensitizing people on radio and in other gatherings. So they call me and tell me that they want to know how the matter is progressing. In training police officers, IPOA is so involved in matters of training, and of late, our board chair has been going to Kikanjo to train police officers on matters to do with IPOA and human rights area. Okay, well, we may not be able to audit the syllabus as a whole, but we make sure that we inform them about the IPOA mandate, and you see, IPOA mandate is safeguarding members of public. And once we have dealt with what affects the public, I think is good enough. Visiting of cells. Yeah, visiting of cells we do. Sorry, I kind of am a stammerer, so sometimes I really don't talk so fast.
It's okay.
But no, visiting of cells, we do inspections, we conduct inspections, and when we do these inspections, we make recommendations. The recommendations that are utilized at the station level, and there are also recommendations that is by the OCS, and then we have recommendations that are also utilized at sub-county, that is a sub-county commander. There are recommendations that would attract maybe say some huge resources that would require to be addressed by the Inspector General, and that is also shared with the Parliament and the CS Interior. So we conduct inspections, but sometimes we know that our resources are limited. So sometimes we make recommendations, but those recommendations will take quite a while for the maybe service to implement. Thank you.
Thank you. And finally, Bwana Hamisi.
Let me try to be very brief. Maybe the first response is to Council Jen about my quest to the judiciary and our legal system to try to improve on its judicial response toward these issues we are discussing. And the position that I'm actually calling upon is that when we have a decisive judicial response, it will actually mean that you are moving from a position of weakness that we have already recognized. Specifically on this particular issue, I may just call upon for us to compare the response of habeas corpus in the Hamed Salim case. I think we know it, petition number 7 and 8 of 2014. If you look at the way Justice Murethi conducted the habeas corpus at that particular time, our expectation is by 2022 we ought to have improved so much. For those who participated, they could have actually noted that the court even went further to call for logs of the police motor vehicles. There were summons that were actually issued in that particular pretest. The court went on further also to investigate issues relating to the transmission and everything. So basically what we're calling upon is when courts have opted that this is an issue that we need to act on, their response ought to be different. Because today in 2022 in an habeas corpus application, you'll be surprised that a court can easily tell you that will dispose of the application by way of submissions and the affidavits that in court, and that is the end of it. So what I'm basically talking about is, yes, as councils have a duty to entice the court that you see there's a new avenue through which you can actually act, and our expectation will be now also court owns to say that there's a lacuna somewhere and we have a duty to develop a progressive jurisprudence in this particular issue. And I believe all of us as councils in this particular place would recognize, even at the time we were watching brief on behalf of our victims, then it came on to improve on our status as councils, even in watching brief under the Victims Protection Act and the active role you are taking. And sometimes in some specific matters where we can actually see courts are so much progressive, you can see the coverage on how the courts react on our contribution when we are doing it together with the prosecution, isn't it? Because we had a time of being told your role is only to come and listen, isn't it? Take a date and go. So when I'm talking about decisive intervention, I mean that the court should actually expand its territory, yes, within the law, but to ensure that it's a fact. Because currently, if you're telling me that you don't have evidence that somebody has been arrested or detained by police, it's as if actually the court is living in lacuna. But a court is a living thing. These things, yes, we need evidence from me, but there's nothing much when I request for these call logs and everything, and the court actually stands strong on that. The other issue, it's about what Councillor Aisha has said, which is very important to note in this particular meeting, is that sometimes we raise a lot of expectation of victims when they come to us. The first day, there'll be a lot of press statements, there'll be a lot of media reporting. By the time they're coming to us, we take instructions, we go to court, we're only left ourselves and the client, isn't it? There's nobody with us. So that's an issue also to be looked upon. And I think this will be a response to my brother's question there about the issue of time. So currently, we are not talking about an issue of the length. We are talking about insufficiency of the available remedies. Lastly, it's about the issue of inquest. As practitioners, and this is a fact, I need to admit, when you're giving instructions, you act on an issue and then you have finalized, isn't it? But now when you get an opportunity to come to engage in such forums, or for those who are in academics, you realize that when you are talking about an inquest per se, whether the inquest will go through or not, it is a first impediment. But again, when the inquest goes through and there's a recommendation of prosecution, if really today you sit and study the trend, you realize that the strength of the inquest, until the court saw it fit to recommend for prosecution, you realize that when you go there now in the actual prosecution, I think the process is somehow watered down to an element that the final product is not actually murder. We can circumvent, we give people 2 years, 1 year, isn't it? And they are off. So the issue of the systematic failures I'm talking about, the inadequacy, insufficiency of response, can actually be noted on that particular way. You just look at a case that started as an inquest as far as extrajudicial or enforced disappearance or questions. You'll see the weight of the evidence there. When it comes now to the actual criminal prosecution, it will deviate. Though we are very tough to see that here there was a mistake, this thing was done deliberately. But when you prosecute, at the end of the day, it will be a misuse of firearm, isn't it? And that will be the end of it. So that gap still exists. Thank you very much.
Thank you, Hamisi. And I would have loved to give an opportunity to the audience, but we are really pressed for time. And my director is asking a minute. We are really pressed for time, but with the respect, with all due respect, very quickly. The microphone is not on.
I thought somebody had muted me. Now, thank you very much. There is a question that Jen has raised, and which I thought it's very important for all of us here to understand. And the question is, how do you ensure that a judge delivers the case on the outcome that you expect? And I think because in this meeting we have lawyers who are practitioners, we have members of the civil society who even participate in the collection of evidence. Access to justice is about even quality presentation. The kind of lawyer that you pick to undo the matter must be divested from the emotions of the case. We shall do all the press briefing, but finally the lawyer must be independent and competent to do research and understand what is the material evidence that I'm presenting before the court. Secondly, the lawyer must be able to raise partnered issues that will point towards the judge to answer the questions that you do, and that comes to what we call trial advocacy skills. Again, the other thing that must be very important is the lawyer must be conversant with the law that is being applied. For example, if in Kenya, for example, we have not passed a law that can guide the judge, you can go to international tribunals and guide the court and to see whether the court then can apply that principle, international convention, to arrive at an outcome. And sometimes in public interest cases, like all of us do, sometimes you might not win, but you might find a case for reform. And that's something that I thought is very important. I mentioned before I could sit down. So preparation is very key, and I'm sure that Uria and your team or promo lawyers, the chair of Mombasa branch is here, will tell that many times cases have been lost, not because the client did not have a good case, but it's because the advocacy skills were wanting. Thank you.
Thank you very much, Director, for that very useful contribution. Unfortunately, we do not have time for your parting shots. So asante sana Bwana Agri Juma, Robert Karani, Kevin Muangi, Rashid Wekesa, and Hamisi Mwazogo. And I invite all of us now to give them a round of applause for the very good session that we've had. Asanteni sana, and you may now go back to your seats. Now, ladies and gentlemen, we are really pressed for time, so I request that we now break for tea, for a health break, for about only 10 minutes, I'm told, by my co-moderator, and then we come back now to proceed with the sessions, considering that today is also Juma, so the Muslims would also be going for the Juma prayers. Thank you very much, and enjoy your health break and tea break as well. Sant.
Look at the CSOs that have been funded under the PLEAD project. And just to remind you that the PLEAD stands for Program for Legal Empowerment and Aid Delivery in Kenya. And it basically seeks to promote the civil society involvement and engagement in provision of legal aid. And most importantly, operationalization of the Legal Aid Act of 2016. So our panelists for today are the PLEAD partners at the Coast region, and we'll take this opportunity to invite them and hear their stories. This session is basically going to be on listening to their journeys and sharing of their experiences in terms of their interventions. So I want to take this opportunity to invite the panelists. I'll start with Huria, Tony, Kituo. Is Ruben here? Okay, he's coming. Kiunga Youth Bunge, Moses Maina, karibu sana. University of Nairobi, School of Law, Dr. Mercy Deche, karibu. Muhuri, Bwana Dennis Chuzi, and then we have two other partners from Kekoske and Chanachena, but they're not able to be with us here today. Karibuni sana. Okay. I think without further ado, and also considering the time that we have and how we need to manage that time, this session is to hear your journeys as far as the implementation of this program is concerned. We want to hear the challenges you have faced. We want to hear your key highlights in terms of the achievements that you have gotten from your interventions. But at the same time, also listen to what recommendations you would have, and also enable our participants here to engage with you. And I think I will start by perhaps giving you an opportunity to introduce yourselves, and also just give us your geographical coverage so that our participants here can also get a better perspective of where your interventions lie. And I'll start with you at the right end, or the left, the far end.
Hello, my name is Dennis Chenzi from Muhuri. For this particular project, Muhuri oversees Lamu County, both Lamu East and Lamu West. And what was the other part that you were supposed to?
Geographical, you give it as a geographical.
Yeah, Lamu County.
Maybe we'll leave it at that for now.
Okay.
And then pass it on to
My name is Mercy Deche. I teach at the University of Nairobi, Mombasa campus, Faculty of Law, this is the only institution that teaches law in this region. So geographically, we are talking about all the coastal, the entire coast region.
Good morning again. My name is Anthony. I work for Human Rights Agenda. Our focus on PLEAD is the access to people-centered justice and rule of law. And our people that we deal with is the poor and vulnerable communities. Thank you.
Good morning. My name is Moses Maina, working for Kiunga Youth Bunge Initiative, an organization based in Lamu. We're implementing PLEAD in Lamu County, specifically Lamu West Sub-County. Thank you.
And Dennis, perhaps we could even start with you. Maybe very briefly, give us an idea of your interventions.
Thank you. Okay, now, Lamu County is a unique county in a way that, as opposed to other counties within the coastal region, it's comprises of a series of archipelagos, and it's divided into two sub-counties, the Lamu East and Lamu West. So we have interventions in the Lamu East area where, from the onset of the project, we knew that it would be a challenge for us to deliver the project in the area. So we had to plan appropriately to know how to intervene in the issues of access to justice in the area of Lamu East, particularly the traveling, because in Lamu East we have a situation where we do not have courts, we do not have a sitting court in Lamu East. And so it was upon us to come up with the intervention of working with the courts to have mobile courts that will be going to Lamu East to deliver justice. So what we did is that we are members of the CUC in Lamu, and through our interventions, through the able leadership of our staff at the Lamu CUC courts, we spoke to the court and agreed that we will be having monthly visits to Lamu East to try and ensure that people in Lamu East access justice and access the courts, more so people in need of the criminal justice system. And to make it, the difficulty comes in the sense that traveling from Lamu Central to Lamu East, you have to take a boat, and it's a 2-hour boat ride for you to get to Lamu East. So you have to move the court all the way from Lamu Central to Lamu East to get to the people and set up the courts and have the people bring in their issues. So it's quite a challenge, but then it's interesting that people are picking up the initiative, and cases are going on. There is support from both the stakeholders and the level.
And perhaps maybe to just follow up on that, in terms of the successes that you have, for example, you've pointed out the challenges, but what would you look at your interventions in terms of successes? How would you describe that? What has been your key highlight?
For key highlights, I would say that there has been an improved improved literacy levels in Lamu County. From what we've seen, from the project, what we intended to achieve from the project was that we wanted people to come in, people to be more free, people to come and access legal services within the county. And so it has been easier for people to come to court, people to report their issues, because initially, because of the security situation, because of the feeling that the government is far. The government is not closer to them. People opted for other means of solving their disputes, extra legal means. So with us going to Lamu East, with us having the courts taken to them, the mobile courts taken to them, people are more appreciative of the law, people coming to report their matters to court. So I'd say that through that and through the mobile court sessions or the legal aid sessions that we have, basing in Lamu East, it's become much more open, and people are much more willing to take the matters to court. It's a plus for us.
Thank you. Yeah. Thank you very much, Dennis. Dr. Marcy, would share that with us.
Thank you very much. May I start by saying that we are not a civil society. The University of Nairobi, of course, you all know that. Yes. But there's a way in which our mandate or our mission fits in and resonates with what civil societies do, because our business is to transmit and transmission and utilization of knowledge, of course, in a way that resonates with the aspirations of the local community in which we are based here at the coast. So in view of that, that's why we've been involved in this project, the PLEAD project on access to justice. And it was in two ways. We had two main interventions. The first one was dealing with children in conflict with the law, directly dealing with the children at the remand home. And then secondly, we were looking at SGBV victims, access to justice for SGBV victims. And here again, we narrowed down to SGBV victims with disabilities and children victims. And what were we doing then? At Likoni, we were, at the remand home, we were focusing on empowering the children to understand the courtroom procedures and be able to speak actively for themselves. And we also, through the partnership with Mombasa Law Society, we had this process of connecting them with pro bono lawyers for the cases which were a bit complicated. Then we have developed manuals, training manuals for TOTs, not just for everyone. And these are community gatekeepers like teachers, chiefs, wazewamta, so that they can be able to disseminate this information, just basic principles of law to the community. And we have also had community awareness physically, just one physically because of the COVID issue, and then through our mainstream and social media. And lastly, we have been able to form law clubs targeting 2 schools, because we are saying we are looking at children in conflict of the law, but there is a pool. These children come from somewhere. A lot of them come from schools. So we have started law clubs in 2 main schools. Shimolatewa doesn't mean that that's where you have most of the criminals or anything. No, it's just a starting point. So Shimolatewa and Oshwal. And so that is what we have been doing.
Okay, those sounds like key achievements. You know, the bringing together the community and the pro bono lawyers, the clubs that you have started with the children. What has been the reaction, and especially when it comes to creating that awareness? What has the response been?
I will just give one main one.
Mm-hmm.
We have received feedback, and I'm looking at Honorable Yator, the magistrate for the Children's Court in Tononoka, that the children now are able to engage the justice system with more confidence. I believe, Your Honor, you'll be able to back me up on that one, that they're able to engage the system with more confidence, and they're able to move on with cases. We have also seen some cases, some children who had been there for long because of maybe 1 or 2 technicalities. We've been able to unlock that, and for us that has been big. And then lastly, just one more, you hear one of the initiatives was to prepare a manual. You know, that's a document for posterity. It is there both in right now we only have it in e-version, and it can be available for use for each and every person here in this room if you want to train people, the community, on the basics of how should a child in conflict with the law, how does the procedure go, right from the detection of the offense right up to the end. Or for an SGBV victim, when I am in court, what should I expect? So that's a document for posterity, and it's a first for us, and it's not just for the institution, but for the entire community.
Excellent, excellent. So perhaps maybe the final one before I move to Tony, on the availability of that manual, when you say it can be, how will they access it? Is it online? Is it something that you may have to send to them? Soft copy?
I think that is something, my boss is here, Dr. Sarah. Let me not say something and get into trouble. I think she should be able to tell us that when she's next on stage. But it is available.
Okay, very good. So we'll follow it up with her as well. Thank you very much. So Tony, give us very briefly the journey of Huria in promoting access to justice. How has it been? What has been the key highlights that you would want us to hear and perhaps engage you in?
Well, thank you, Zainab. I think before I get there, if you look at the 2018, 2019, and also 2020 poverty index, you'll see that majority of Kenyans are very poor and cannot afford legal services. And even for those who can afford those services, they do not have what we call legal literacy. And that has been our concern, because right now if you go to prison, if you go to police cells, those people that you find there cannot even afford to give a cash bill of 2,000. Okay? So when you look at access to justice, and I think as an organization, our main focus has been on the part of accessibility. Because if we do not, or if we are not able to facilitate accessibility to these poor and vulnerable persons, then it will be difficult for them to realize this right that is enshrined in the Constitution. So that was our first point of focus. And how, as an institution, are we able, or how have we been able to realize access to justice? We have been able to see, or rather to convene actors around access to justice. I mean, the right stakeholders, and I think as an institution, we are now a member of a CUC, where we are able to discuss some of these pertaining matters and how litigants can be able to, access justice and realize justice. Because if we do not bring this conversation with the right stakeholders, then the problems will keep on repeating. And I think from the number of interventions and meetings we've had, I think it has been able to realize that, look, there are people who are languishing in prison and in remands, but based on very small and flimsy reasons, we can make good use of these individuals and bring what we call restorative justice. So from that background, and we were able to look at where the problem is. And we started by convening actors by trying to build their capacity. Because even when we talk about, a violation of human rights, remember we have these human rights violators, all right? So who are they, and how can we reach out to them and build their capacity so that we do not see a continuous violation of rights and people, continue languishing in prison? So we did a number of assessments to know where the problem is, and we realized that, look, accessibility is very important, and we, as an institution, we were able to come up with what we call the legal aid centers. Because if someone cannot afford a lawyer, then what can we do so that we are able to make him be represented? So the legal aid center has really worked in terms of offering, pro bono legal services, and of course the legal literacy and awareness to, some of these communities who need our services. But we are not just there to wait for them to come. We are also trying to reach out to them so that we are able to empower them. And I can tell you for a fact now, most of the communities that we have reached to are able to demand for justice, because some of these violations happen, but communities are reluctant to demand for, the justice and, to look out for people who can try and help them access it. So as an institution, we've been around that, and I think maybe I'll talk much later. I'll talk much what we've been able to do exactly as an institution to address that gap.
Okay, thank you very much for that overview. When it comes, for example, because you talked of bringing, the stakeholders together, what can we learn from that process? Even in terms of reaching out, because sometimes you get an indication that coordinating that or coordinating those networks is not as easy. What lesson can we pick from you in terms of bringing these stakeholders together for the sake of promoting access to justice?
I think there are stakeholders that traditionally have been known not to be actors or who do not contribute to access to justice. I'll give you for an example, the county government of Mombasa, or these county governments traditionally have not been, part of, promoting access to justice. But if you look closely, most of these county governments have these county bylaws, which in byway contribute or facilitate access to justice. So when we bring stakeholders on board, we try to highlight where the gap is. For example, we have county assemblies which pass, county, legislations. So some of these legislations are supposed to be anchored, with a human right first, so that we are able to see that they contribute largely. So bringing stakeholders together makes them realize that, look, we have a responsibility to contribute in terms of enhancing access to justice. And that is the reason why even the county government of Mombasa was able to look at that. If you look at the County Attorney's Act of Mombasa, it provides a provision that the Office of the County Attorney can be involved in the provision of legal aid. That is something that we realized we could take advantage of and make them realize, look, they have a contribution in terms of accessing justice, or rather enhancing access to justice. That is the reason why even the county government was able to provide a free space for the institution to host the legal aid center. So I think bringing stakeholders together, we are able to realize where the gap is and where the contribution is in terms of enhancing and facilitating access to justice. Thank you.
Thank you very much. Moses Maina, tell us your experience.
Thank you, Zainab. I think Muhuri is working in Lamu. We're also working in Lamu, but specifically we are focused in Lamu West Sub-County, what is called, quote unquote, the mainland. So of course we have the mainland, and Lamu, we have the Lamu East is mainly now the archipelagos and the islands. So our focus is mainly on the mainland. And I think the main challenge that we foresaw, I think there was a mention yesterday that there's a court in Lamu, Mpekitone Law Courts, but initially it was a mobile court before it was established as a court. But I think there's still that alienation from communities in Lamu West, in the mainland, towards that court. Lamu mainland is very vast, from Hindi to Witu, a very huge area, and that court is not able to cover that geographical scope. And so most people are alienated from the court system, and they don't understand exactly, they don't see the value of really going to court and taking the cases to court. And there's also the trust issue in the justice system, the local justice system, by some communities. So our main focus was just trying to consolidate and sensitize communities around the importance of accessing justice. And of course, despite the fact that we have that court, it's too far away from some people. So if someone is traveled from court and back, they'll have to use a lot of money, of which people, the many communities are not able to meet that cost. So just trying to examine strengthening alternatives to imprisonment, diversion, alternative justice system, and of course the implementation of the AJS baseline policy in the mainland. So we've had a kind of a multi-pronged approach to, first of all, help people access justice and legal aid services, and those people who are not able to access justice or who are too far away from the court, to come up with a way that they can solve the issues at the community level. Of course, we've done this through establishment of Adr Centers across the whole mainland. These centers are basically community-based structures, and they have a center where they have a committee and they're able to solve cases in recognition of the court. And the court has also recognized these centers. In the Mpekitone Law Courts, they have actually opened a register for diversion to these centers, and of course to the court annexed mediator. So we are seeing the court working with these local community-based structures to strengthen diversion. We're also working with the local police stations to strengthen diversion at the police station level and to sensitize the police on the importance of not all cases have to go to the prosecutor. They can actually divert at that particular level of the police station, and they can divert it also to the ADR center. So this kind of multi-pronged approach has really helped us in strengthening access to justice. And of course, we're also doing legal aid clinics across the whole mainland. We also have a paralegal system. We have paralegals who have been trained. We've built the capacity of specifically women. Most of our paralegals are women, are girls, to solve rampant SGBV cases or to help or give legal advice on matters of SGBV, yes, or defilement. which is very rampant in the mainland.
Mhm.
Yes.
Thank you very much, Maina. Maybe I'll just follow up with a question. In terms of what you've just said, put forward, that sometimes people, they lose that trust in court or taking cases to court. And I'm sure you may be having examples of those that you have convinced otherwise. Would you want to share that with us so that we learn something from that?
Yes, so of course we have so many communities in the mainland, and each community has their own particular culture. So we have some cultures that specifically they don't believe in the formal court system. Some particular like Ormas, Somalis, they have their own ways of solving their issues. What we've done, particularly in the second day of this program, we came up with an idea where we worked with the DPP, the DPP based in Peketoni Locots. And we had a caravan, a weekly caravan called the DPP Caravan, where we went to all these, across the mainland, specifically targeting now these particular communities and trying to sensitize them. And also, these communities, upon seeing that the DPP is supportive, of course, the main purpose was just trying to sensitize them on the law in the cases that they're supposed to be diverted at that particular community level, but also now trying to build that rapport and trying to show them that the court system is there for them and it's not some mysterious thing. It really worked for us. We also came up with a weekly talk show with the DPP, so the DPP was able to speak directly to many communities that are not able to access court services, and just trying to teach them on the court procedures and laws that can help them build that trust with the judiciary. So I think those are particular examples of how we've been able to build that trust. Just bringing the DPP closer to the communities. The communities actually saying the DPP was very important for us. Also working with the CUCs. The CUC in Peketoni Locots has been, I think, has not had a lot of support in terms of outreach. So we came up with an idea where we had CUC outreaches to particular communities. We went to the probation officers, the children officers, the DPP, the chairman himself, to local communities just to hear the kind of social justice challenges that they're facing. And upon seeing, and upon this interaction between communities and the CUC, then there has been that kind of opening up, and people are able to share issues, and people are now able to actually now start trusting the formal court system. So I think that is what we did specifically, but of course there are so many other challenges, especially when you look at issues of defilement, which is a very, very rampant issue in the mainland. So we have to think around how we work with all stakeholders, particularly the county government, the national government, the local community peace structures, to sensitize, because these are issues that emerge and we have this information from the court system. More than 60 or 70% of cases in Peketoni Locots involve defilement of children. So these are very big issue, and the culture has been a barrier. Most of the communities are not able to open up. It's a normal thing to marry off a young girl. Some girls are booked at a very young age, they are married off. So if you go to a community and try to speak on it, then it becomes, you're doing more harm than good. So it needs to be an issue that is examined deeply, and we have to bring all actors together to address this particular issue.
Thank you, Maina, for that. Ruben, while you're away, we are sharing experiences in terms of the interventions you've had through the PLEAD program, and would like our participants to hear from you, perhaps very briefly, the key highlights of your achievements, interventions that you...
Okay, thank you, Zainab. As part of Kituo's interventions or successes in their interventions under the PLEAD program, we were we're able to strengthen the civil society network within Mombasa County. And this has been achieved largely through the meetings that we conduct on a quarterly basis that targets the various civil societies within Mombasa. And the civil societies come together to discuss issues around security, issues around good governance, issues around health. And the most important or the most significant outcome of these out of these meetings has been the created synergy within the network. So you're able to have good governance and proper partnership within the networks, as well as influencing the county policies, as well as influencing the Mombasa County policies. And this has been witnessed through the lobbying or the petitioning of the county government in terms of the budget making process, through the network, through the civil society network as well. We've been able to impact on the various policies, that is the health policy, the youth policy, and as well as the legal policy, in like what my colleague TJ has alluded to in terms of implementing of the legal aid policy within Mombasa County. So this has been achieved through the working of the civil society network within Mombasa County. The other achievement or the other outcome from our intervention under plead has been our work with both the community justice centers that we've established, as well as the prison justice centers. And we have been able to task the community paralegals that we've trained with ensuring that they are able to impact within their communities and bring about access to justice at the ground level. So our community paralegals are able to interact with their community members, and they are able to bring their issues to them, so that we don't have a case whereby if someone has a dispute within the locality, then they have to look for an advocate who they might not have the capacity to engage, and they're able to interact directly with people who they see on an everyday basis. But these are people who are capacitated in terms of handling legal issues. As well as the prison justice centers. These have been, I believe, the most successful justice centers within our program, insofar as their advocacy for abolishment of the death penalty within the penal code. And it is through the advocacy by Kituo that we are able to have the Murwatetu case, and it is through that advocacy that we have within the justice center, that is Shimolatewa Justice Center, both men and women prison facility. These prison paralegals helping their fellow inmates to petition the courts on individual cases, and the case rate, the case success rate has been remarkable, considering that most of our paralegals have been able to draft and successfully petition the courts in terms of their fellow inmates' sentences either being reduced or the inmates being released entirely. Another outcome or another success that we have been able to achieve through our program has been the use of or the capacitating of the different paralegals, and we are working towards now having skill-based capacity building, and we hope to conduct we hope to have them capacitated in terms of being trained mediators. This will go a long way into ensuring that the community paralegals are trained and certified mediators, and they're able to engage with the court through the CUC, whereby the CUC will have the avenue of referring cases to them. This will go a long way into reducing the backlog of cases that we have in our courts, And this will also help to achieve what the judiciary has recently rolled out in terms of the alternative justice systems.
Okay. Thank you. Thank you very much. Dennis, I'll come back to you again. In terms of perhaps the biggest lesson out of your challenges that you have experienced in your interventions, what has been the biggest lesson that we can also learn from, even as participants who are here?
Well, I could say, in terms of the biggest lesson, we are still learning, but then what intervention needs to be given is that more needs to be invested in the people of Lamu. More so because due to their geographical location and where they are situated, it might be a feeling that maybe the government has left them out, and the justice system does not really reach to the ends to their ends. So people might, the people in Lamu, the residents of Lamu, might want to explore extralegal means or explore other means of getting justice. And it doesn't help that there are so many police officers or there are so many security operators within Lamu County, who in a way act as in a way they help, and in another way they act as an impediment to justice, because you find that they are one of the push factors that leads to the insecurity in the region. That has been discussed severely in Lamu County, and you have seen government operators going to Lamu and trying to address the situation. But then we need to build up on the synergy, the commitment or the communications between government and the security sector and the judiciary and the criminal justice sector stakeholders, because we feel like that is a big area that if it's not addressed, then we will keep on having these issues where people do not want to access the available channels of accessing justice, and they'll opt for the other means that are not legal in nature.
Mm-hmm.
Yeah.
Thank you very much. Dr. Deche?
Thank you very much. Listening to Ruben and Tony, I'm proud of them. They were my students at the university, if I may say that, but it's a pleasure to share the platform with them. We are talking about the lessons learned. I have a main lesson and a semi-lesson. The first one is we have come to understand that as far as justice, access to justice is concerned, there is no one sector or civil society that can hack it all by themselves. We are talking about a wheel, we are talking about a chain, and we are as strong as the weakest link. So we must all work together or fall together. That is one thing we have come to learn, because for instance, even that manual that you're hearing, we came up with, it took the representation from the judiciary, from the ODPP, from the county government, children's department, probation, each, and then of course the gender office and persons with disability, to each come up with a chapter so that we could address the various issues. And so for me, that is one great lesson, that it's not about one person, one entity, one expert. We all have to work together or collapse together. But the even greater lesson that we learned, and this is something we were discussing with Dr. Sarah, is that as far as persons with disabilities concerned, and I say this aware that there is a session that's coming up with regard to persons with disability and access to justice, we've only just scratched the surface, because that was one of our initiatives, and most of the times we are so focused on, we think meeting the needs of persons with disabilities is putting a ramp at the court entrance so that a wheelchair can pass. But the whole diversity of persons who are visually impaired, how do they even identify a person in court? Persons with challenges, hearing challenges, who cannot speak. It is just a whole wide constituency, and we were amazed at how little we knew when we engaged that constituency. So for me, it was in fact the beginning of a lesson learned. The beginning of learning a lesson. Thank you.
Wow, that is very interesting. It's from there. I think the importance of complementing each other's efforts. Because you find each and every one of us, the CSOs, the development partners, the duty bearers, to play. Because I think this no. It also comes to the importance also having very strong networks, the importance of sharing, communication and information so that you're able to tap in each other's strength. And then, for example, abilities, when you look at the LEAD program, it is very, very clear that it wants to reach out to those who are poor and marginalized and PWDs as well. So that, even as you're designing those, you should always have that at the back of your mind, that the programs you have to mainstream the needs of those with disabilities. I think that is one thing that I wanted just to highlight. Tony, from your experience, the biggest lesson that has come out of this program, which you think you can share, and also perhaps give us also a recommendation.
Thank you. I think one thing that we've come to learn is that Kenyans are very litigious people, that everything that happens around, you hear people say tutakutana kotini. But then only to realize that we have so many other avenues of resolving problems or issues or conflicts within ourselves. And as much as people are yet to embrace, the idea of alternative dispute resolutions, something needs to be done, especially for communities within the urban centers, or rather within, areas like Mombasa. You realize that sometimes people come with high expectations to help them assist on issues that could be resolved, at home or, within the two conflicting parties. And it is the high expectations that make them, want to seek justice in the manner and way that they think they are. And so the lack of legal literacy, even for the professionals and people who have money who can access some of these services, needs to be, to be looked into. Having said that, I think majority, if you look at around 60% of the cases we've received, focus around women. The complainants are women, children, and persons with disability. So this tells us that women have their rights are being violated and abused left, right, and center, and we need to see how can we in future start designing start programming intervention around that sector or that area. The other thing that we are looking into is building capacity of actors. There is an assumption that some of these access to justice actors or justice actors have the capacity to deal with what is put on their table, but only to realize that there is need for continuous capacity building, and do a lot of trainings so that we are able to advance some of this agenda in terms of human rights and whatnot into them, because while we were working with the county assembly, for instance, because our take was to ensure that we have laws that are being made at the county assembly with a human right face or with a human right lens. So we realized that there's a challenge even for those laws that are being, being made by some of these actors have a problem. So how do we bring our expertise in terms of, that area and whatnot. So the other issue that I think we can address is the issue on how we can bring actors together to contribute on certain areas and opportunities. So I think because if we do not seek a lot of consultation within ourselves and act in unison, then we might be doing a lot of duplicity in what we are doing, and we may not be getting where we want to go. Yes, thank you.
Thank you very much, Tony. Maina, I want you to speak on the issues of women, persons with disability, and the lessons that you've learned in your project. What can we pick from you?
Yes, so I think one of the biggest lessons we've learned through implementing PLEAD in Lamu West was, let me begin by saying at the beginning of the program, I think we were very scared to implement PLEAD because we thought it's, there's no lawyer in our organization. So we thought it was a really technical program. But what we've learned is this program, we've basically given it to stakeholders to run it, to be the face of the program. If you come to Lamu West, the face of the program, I think, is the DPP and the resident magistrate. They really own all the interventions we are doing. So I think the importance of putting these key criminal justice actors at the forefront. They know exactly what kind of cases come to court. They know exactly the kind of social justice issues in the communities. And so we give them the freedom to really express themselves through this program and to intervene. I think for women, I think we've been very particular in trying to build the capacity of women, particularly our paralegals, in trying to bring to light some of these issues like defilement and SGBV and FGM in particular communities like the Orma. So we have paralegals from these communities, and they're also working closely with the DPP. In fact, one of the issues that came up was the preparation of documents by these paralegals. So if maybe they're assisting a client to come up with an affidavit, and the affidavit, I think it's not written in English; it's in Swahili. So we worked with the magistrate, and now the Swahili versions of the affidavits can actually be admitted in court. They're admissible in court through these interventions. And so we have affidavits in Swahili. They're able to prepare these documents. We also have information leaflets specifically looking at reporting of defilement cases. And so these paralegals, their work is trying to give these leaflets and translating them to communities, trying to sensitize them on reporting these cases. So we've been particular on sensitizing or building the capacity of female paralegals. We also have Adr Centers, and we have women in these committees, in these ADR committees. We find that some communities, women are not allowed to sit in a kind of decision-making structure like an ADR committee. But through this program, we have women sitting in these committees and trying to specifically advocate for cases of women and take charge in leading cases involving women, particularly women who've been violated or something, and they also have a link with the DPP. So having a direct link with the DPP and with the court system and the paralegals working together has been very efficient for us through this program.
Thank you very much for that, Moses. Ruben, your biggest lesson, and perhaps just a recommendation as well?
Yes, so part of our biggest lesson has been largely influenced by the COVID-19 pandemic, and in terms of access to justice during that time. You noticed that most of the court processes were changed or had to adapt to the new circumstance that was facing us all. And the key lesson learned was how to improve the accessibility of justice to people who are not IT savvy. So with the shift from manual to e-filing especially, we had to now come up with the programs, or we have to come up with the facilitations on how litigants can go about e-filing, and how especially litigants can convene or can present themselves before the court, can file their documents, and how the court goes about the normal court procedures, but using the technology. So that has been a key, I would say a key knowledge gained so far. And the one avenue or one opportunity to address it has been now to be able to transmit the new guidelines on e-filing to the rest of the Kenyans within the county, and especially how we are going to empower our community paralegals so that they can educate the litigants at the ground level on the new court processes and how to go about accessing justice through ICT.
Thank you very much. I want to bring a very key issue as far as project implementation is concerned. And this is the issue of sustainability. I think to all of you must be facing that challenge. In terms of what you have in mind, considering that even the funding, there's a lot of restrictions in funding, the declining revenues and things like that. Dennis, what do you have in place to either, support you in continuing with the interventions, or if not, what are you going to do about sustainability?
Thank you. In terms of sustainability, throughout the life of the project, we have been training arbitrators who have been getting the knowledge on how to deal with cases, because you're looking at cases that are not criminal cases that do not need to go through the criminal justice system. So we are trying to make sure that people in Lamu East who do not need to come to the court at Lamu Central have a place where they can go to work on their issues, to talk on the cases that they have and to have them resolved. We are also working with the Paralegal Society of Kenya, because we've been training paralegals throughout the counties of Lamu, and we're working on them getting certified so that they could be the leaders, they could be the people that, the face of the program, even after we've left. They could be the people that be training and addressing issues. Maybe if people want to go to court, if people want to get advice on issues that relate to the law, then these paralegals will be the people that will be charged with the mandate. So we are in conversations with the Paralegal Society of Kenya to come and certify them and have them gain the knowledge to do what they ought to be doing.
Thank you very much.
Welcome.
Dr. Deshi.
On the issue of sustainability, what the university did from the word go was to build the project or conceptualize the project around the existing programs, the programs that were already existing at the university. For instance, when it comes to legal aid, we have a students' organization that we call SALA. I was just whispering to Tony here to tell me what SALA stands for, the SALAR. But it's around Students Association of Legal Aid. Yes, we have that. The students are here, they'll tell me better. But we have that organization, and it's the one that has been going out every other week to the remand home. You see, if I was to be relied upon, or Dr. Sarah, to go there every other week, then it can become problematic. So we built around that, and you know Salah was there before the project. Salah is going to continue being there after the project. So we are not worried as far as the sustainability is concerned. And not only that, we have the Mombasa Law Society. How the University of Nairobi Faculty of Law operates here at the coast is that it works very closely with the Mombasa Law Society. So when it comes to the pool of the pro bono lawyers, again, we had that pre-existing network or relationship, and it's what is going to continue. Then I told you about the law clubs. So when we were choosing the schools, we were very intentional about which schools to start off with. Again, we went for the schools where we had pre-existing relationships in as far as mentorship programs was concerned, the Shimolatewa and Oshwal. So that is what the programs are not so much financial intensive as the other, maybe I call them human resource based, and the resources, the human resource, we have been able to draw from pre-existing relationships. And of course, lastly, when you put some of the outcomes in form of permanent record, again I go back to my manual. I really love this manual. So it is there for posterity. And apart from the manual, we also have some small clips on SGBV survivors, where we have captured SGBV survivors and lawyers, feeder lawyers and other lawyers, just talking about what should happen. So that is something, again, for posterity. Thank you.
Thank you very much. Tony, over to you.
Thank you, Dr. Dech. I think maybe for avoidance of doubt, Dr. here is a practitioner, and he has been my lecturer. I might have forgotten about the definition of Salah, but I can't forget the concepts on land law that you taught me many years ago. I think maybe to come to the point, I think as an institution we have leveraged more on technology, and I think as an institution we shall continue offering what you call the free legal aid advisory call sessions. That is something that will continue even beyond the existence of the program. And I think we receive so many concerns, and we address those concerns as far as other counties, and Nakuru and such. Number two, we have been able to broaden our pool of partners and actors, and as well as referral mechanisms, including a pool of pro bono advocates. So as far as representation and in terms of public interest litigation that we do, we are sure that we shall continue offering such related services to some of these communities that are indeed in need of such services. The other thing that we still continue to leverage on is on the Legal Aid Center, because this is a center that was established to help communities address some of these concerns on access to justice. And because we have the partnership with the Office of the County Attorney, so we are able to get, a lot of consultations as well as human resource, which we know, and of course the building that was offered by the county government, we still know that our renewable MOU and partnership will still continue, so that we address and we help them address, or rather, we help communities access justice. The other thing, we have been doing a lot of capacity building, and I think we have a pool of human rights mentees and mentors that we have mentored through the way, who we shall also be seeking their support in addressing some 1 or 2, 3 concerns. And I think we also work closely with the community at the grassroots. We get a roll of referral cases from them, so they're really working towards ensuring that where we cannot reach and where we are not situated at the grassroots, we're able to get those cases for redress. Thank you.
Thank you very much, Tony. Moses, very quickly.
Thank you. I think before I go to sustainability, I think it's important to highlight some of the infrastructural gaps that are there in terms of trying to sustain the efforts that we have. In our engagement with the justice actors, there are so many challenges in Lamu West. Basic challenges like we don't have a holding facility for children. who are in remand or those who are sentenced to custody. Basic challenges, you go to a police station, they don't have a printer or a computer. So that's something that it's really surprising. And a basic thing like that can undermine access to justice at that particular police station level. And you find that a police station has one vehicle. That vehicle is supposed to ferry remandees, adult remandees, and children, watu wanaekwa kwa hiyo Land Cruiser pamoja. So that's something that is very, very sad to see. And I think it's important to have all stakeholders sit around and discuss these issues. We also don't have gender desks at any police station, I think in Lamu. There are no gender desks. Even the female police officers who are there, they're not trained on how to handle SGBV cases that are reported at the police station. So I think we don't have a rescue center for sexually molested, defiled children. That is something that the DPP and the magistrate really insist on us to lobby together, lobby the county government and see how we can come up with a center where the many defiled children can get a haven. So I think these are the infrastructural foundation is absent. In as much as we talk about sustainability, then we have to think about how we can address these gaps. But I think as an organization, what we've done, of course, we have the Adr Centers we've set up. We are currently in discussions with the county government to sign an MOU, just like Huria, to have them give us one of their buildings to set up an Aligoid center. That I think will be done by the end of April. We are thinking about innovation. We have an application that we are running with the Aga Khan Foundation, but it's specifically for schools. We are thinking about kind of having a similar application for this program, where people are you are able to find a paralegal through an application. So you're able to through that application you choose as a user, and then you're able to be taken to a database of paralegals that are near you, and you can select one, and you can meet up. Because the challenge has been connecting these paralegals with people who need them in the vast mainland. So I think that is something that is ongoing. I think that application is in place, but I think we can have a similar application for plead, and that is something that we're trying to innovate around and see if it can come to fruition. So I think that's it.
Yeah, very, very interesting interventions there. Ruben? In terms of sustainability, where are you?
So in terms of sustainability of our plead program, we have been able to increase our pool of volunteer advocates, and these are advocates who willingly register with Kituo to provide pro bono services when need arises, and we refer cases to them when clients come to the office. As well, we are able to link the volunteer advocates with our community paralegals who work closely in cases where a community paralegal feels that a person needs legal assistance and legal representation in court. They're able to contact directly the volunteer advocate who is able to assist them and provide the legal services required. The other sustainability is the use of the prison paralegals who have been able to, who were even working during the COVID restrictions, where the public was not allowed to access the prisons, but they were still continuing with the assisting their fellow inmates in terms of filing the documents, as well as notifying the prison authorities with regard to any issues that were arising. So the existence of these paralegals within the prison justice centers has ensured that these inmates who feel they are aggrieved by the system are able to get recourse even when they are not able to gain access to an actual advocate within the prisons.
Thank you, Ruben. Ladies and gentlemen, I think you've had a chance to listen to our panelists. You've had them share their experiences, their achievements, their challenges, and even some have, we've gotten some recommendations from them. I think before I give them an opportunity perhaps to even give us their last word, would like to open it also to you if you have any questions for them. But again, I need to be reminded of how much time we have. Bwana ED, we are pressed for time. Okay, so maybe I'll allow, maybe like if there are 3 questions, if any, for our panelists, before I give them an opportunity to perhaps give us a parting shot. Very quickly, be very specific. Thank you.
I'm Omondi Sam, and my question goes to Ruben. I wanted to know how often do they do their paralegal trainings, the requirements and training duration, the community paralegal trainings, time, requirements, and training, often. Thank you.
Time, requirement, and duration of your paralegal trainings.
Thank you very much. I think first is to comment the panelists, and especially Dr. Deche, whom I commend for being a pioneer in empowering communities. My question would be, the University of Nairobi has done well. I've heard what you've done. But I wanted to find out what you might be doing the county of Tana River and Kwale. You remember Kidungalanga? When I use that word, anybody coming from Kwale knows what I mean. To empower the girls, to deal with men who marry young girls. And in Tana River is about the dispute resolution by Matandela, the small courts that even purport to deal with sexual offenses. What is it the university is doing to build capacities of the CBOs around there? Thank you very much.
Thank you very much. If there are no further questions, we'll give them an opportunity. Oh yes, we have one more. Then we'll give them an opportunity to quickly respond. We also manage time.
Okay, my question goes to Dr. Masideche. You've talked about the issues of people living with disabilities and what much is needed to be done. So what is your roadmap as University of Nairobi? What is the plan and your roadmap as University of Nairobi?
Okay. So, in terms of answering your question, with regard to paralegal training, we do it on a frequency, on a yearly frequency. So if we train paralegals, let's say this year in April, then April or next year around the same time, we provide further training or a refresher training with the same paralegals. Or if perhaps circumstances have changed and we have 1 or 2 paralegals leaving the group, then we conduct the refresher training with them. But we ensure that we are able to impart similar and even more skills on them in terms of legal principles. For the duration, it's usually a week-long training. We have, at the end of each training, we usually conduct legal aid clinics to help the trained paralegals to able to apply the skills that they've learned. And for the requirement, it's we have a usually minimum requirement that you at least have a Form 4 living certificate, so that this will help in terms of you being able to document the cases that you hear or you handle, and also being able to go through the documents that you may be provided by the people who come to you for legal assistance.
Thank you. Munidhia is asking what we have done in all those places. When the Children Act was enacted, Munidhia and I were in the team that went to disseminate it in those marginalized districts. There were districts then. Of course, that time I was an activist and would all go and arrest those old men who are marrying young girls and such things. But now, our mandate at the University of Nairobi, our entry point is to provide education and training and also transmit knowledge. So, we have to stay within those parameters. So what have we done as the University of Nairobi? What we have been doing is to target TOTs, trainers of trainers, and those manuals are for the TOTs. So in effect, what we are doing then is to empower them to empower others. We train them and then we tell them, go forth to wherever you come from, and what we have trained you to train others. And if you need us, we will be there to assist. I hope that is sufficient, Munidhia. And Jane is asking the roadmap with regard to persons with disabilities. And because of time, can you allow me then, that will be my parting shot also, because I intended for that to be my parting shot. I'm saving on time. This is what I think. First and foremost, can we disaggregate persons with disabilities, because they are not one group. We have various kinds of disabilities, physical, visually impaired. Some people cannot hear properly, others cannot talk. So that for me is the beginning point. When we are talking about access to justice, let us not lump people together, because the experiences of this group of people is so different when they engage. My only problem if I'm physically, I have physical disabilities, may be getting to the courtroom, the physical access. But there is this person who will not even be able to see what is happening in the courtroom. So for me, Jane, that is what we have been thinking about in our own limited way. We are thinkers, but not implementing. When it comes to funds, we don't have that much money. But that should be the beginning point. So people who should hear and act accordingly, please hear and act accordingly. Let us disaggregate the category of unpack persons with disabilities. They are not one uniform group. The other issue then, my parting shot again would be, is that can we hear then the voices of persons with disabilities and children? Because most of the times what we do when it comes to access to justice, I want to talk for the person with disabilities. It makes a lot of difference when we hear the voices, when we hear the children, and that is why we brought in the law clubs, so that we are talking about children in conflict with the law, then we are talking for them. Can we hear them right from the word go? One of our trainers was a person a deaf person, and of course that meant that we had to have a translator throughout. And it makes a difference when we are trained by that person, and instead of training on disability etiquette. So that would be my parting shot, that we are not like members of parliament or senators for this category of people. They also have their voices. Let them be heard. Thank you.
Tony, in 1 second, your parting shot.
What I will say is that the worst form of injustice is pretended justice. And when a righteous man leaves stage, his light must remain. What I mean is this, as we do the good work in supporting communities, let them feel the impact that we're doing. And as UNDP supports this institution, to address the plight of vulnerable communities, women and children. Thank you.
Yes, so I think for my parting shot, I think we really have to be honest in trying to address the gaps in access to justice, and we have to be strong and show strong intent in trying to address these issues. I think what we've learned is that engaging these critical stakeholders, they really open your eyes to identifying where the gaps are. So plead, for example, should not work alone or in isolation. Plead should involve other critical stakeholders. We've seen, for example, Lamu, of course, has been in the news for the past couple of months due to attacks. And there are so many underlying issues. One of the underlying issues is land, of which land has been a very critical social justice issue. So just trying to see how the CUC can actually, there's actually an engagement forum called the CEF that examines drivers to violent extremism. And we don't have a CUC representative in that CEF. So trying to see how we can work together as all stakeholders to address underlying issues, to address gaps. Lamu West, for example, has no children officer. A whole sub-county without a children officer, you find the probation officers are doing the work of children officers. So, yes, thank you. I think that's my parting shot.
Thank you very much. So, as my parting shot is that we need, as plea partners, to lobby for full implementation of the Legal Aid Act, so as to ensure that we have achieved access to justice to each and every Kenyan.
Thank you very much. Can we have a big round of applause for our panelists? I'm sure you've all learned quite a bit. We are not going to repeat what they have said, but we've given you an opportunity to hear from them. And this opportunity should not stop here. You know who they are, you know their faces, you can get their contacts. So if you need to kind of engage further, I'm sure there's opportunity also to do that. And I think with that, once again, we want to thank all of you for this session, and I'm sure these discussions will continue. Thank you very, very much, and thank you everyone. Asanteni sana.
So thank you very much, panelists, and I wish to welcome the next set of panelists who will be talking to us about access to justice for vulnerable groups. We have Honorable Viola Yator. Please come to the podium. And then we have Jane Anyango. I have just appropriated my student's phone and come to the stage with it. Jane Anyango, and then Mr. Joram Tsotso. I can never pronounce it properly. I think I need a session. Phyllis Mwema, do we have from Kekoske? And then we have Mr. Nick Maku. And I'm trying to remember the name representing Juliet. Jemima, I'm sorry, please Jemima Karibu. Do we have Gabriel Kitili? Is he in? We may need an extra seat. Thank you. And as I come up to the stage, I would like to applaud the team that was here before and say that we have been interacting with the civil society for the last 10 years as a university, and what is increasingly clear is that the caliber of civil society in the coast region has really gone up. I must say that the standards are higher, and we do appreciate the work that they're doing. And I think what best represents what they have told us this afternoon is best depicted by the methali kidole kimoja hakivunji chawa. You're all doing excellent work, different work, but you're all contributing towards access to justice. So thank you very much, panelists. And throughout the symposium, we have been focusing, of course, on people-centered justice and saying access to justice for all. But this session, we would like to focus on vulnerable groups. And just to start us off from a conceptual level, as you introduce yourselves, please also say, why is it important to focus on vulnerable groups? Isn't it enough to say that we want to enhance justice for all? Doesn't all stand for really all? Why talk about children? Why talk about persons with disabilities, etc.? But we start, introduce yourself and then say something about the conceptualization of vulnerable groups. Joram? I'm just being whispered to that we have not allowed people to even stand up for a minute and stretch. And she was even saying, let them have an energizer. Okay, 1 minute, please. Our energizer person, Tony. Are we going to pepeta the ball, or what are we going to do? Tony, where are you? I think he's gone out. And you're all civil society people, so you do this all the time.
Good morning, good afternoon. Are we tired? Huh? Where are our voices? I normally expect civil society to bring up their voices, because if you don't bring up our voices, no one can hear us. Good afternoon. Yes, that is better. Now, because we are in Mombasa, we are going to do an energizer of writing the word coconut. The word? Coconut. So you lift up your hands up, and then we go on our left, mpaka chini, eh? No. Some people have changed. I'm not saying you change your hand. Our C is going on the left. Huh? We go on the left up to down, touch the ground. Thank you. And then put your hands together. I can't put mine, but put your hands together up. And then another C, go on your right, up to down. And then another O. And then an N, you go down. And then you hands up. And then T. Put your hands across. Applause for yourself.
Take it away, Joram.
Good afternoon, everyone. My name is Joram Mutsotso.
The back? Okay.
Yeah, Joram Mutsotso from Clear Kenya. Clear Kenya is a program of Kenya Christian lawyers. We have the Mombasa office. Then the Mombasa office deals with the coastal region that covers the entire coast. And we provide legal aid. And specifically for children, the Mombasa office specifically provides legal aid for children. And for children, because children, they cannot speak for themselves in the African
setup, especially from the cultural background where we have all brought up in setups that believe that children are there to be seen and not to be heard. And so we have come up to say these children are people, they are human beings. As we are saying justice for all, they also need justice because we need to know what they want also. That's why we want to hear them speak. We want to hear them talk.
Yes, good, all protocols observed. Good afternoon. My name is Jane Onyango. I am an advocate of the High Court of Kenya, practicing under my own law firm in Mombasa and Mtwapa. Personally, I am here to represent FIDA as the coast representative to the board. What FIDA does, FIDA is a women's rights organization. Okay, I'm being told that I was not being heard. I've said my name is Jane Onyango. I am an advocate of the High Court of Kenya. I do represent, in this panel, I am representing FIDA as the coast representative. What is FIDA? FIDA is a women's rights organization that has 3 offices, Nairobi, Kisumu, and Mombasa. I'll speak specifically on the activities by Mombasa. We have 2 programs that we are running. One is on access to justice, and one is on women and governance. And then the other one is on women and governance. What we do under access to justice is that we have several interventions. We have a group, the legal representation, where our in-house advocates do take up legal representation on behalf of the vulnerable clientele that comes to our offices. And then we have the mediation sessions where most of the matters that come to us undergo mediation, and we have mediators, trained and qualified mediators within our organization that we work with. And then we also have the issue of counseling, where we do several counseling for our clientele. We have the group counseling, we have the couple counseling, and the individual counseling. And counseling also, there's the aspect of the group therapy for the clientele that comes to visit our offices. And then we have the issue of self-representation, where those clients who come to our offices, and we empower them and equip them with the knowledge of the courts so that they're able to effectively represent themselves in court without the need of a counsel. And then we also have the pro bono lawyer scheme, where we invite lawyers. We have lawyers that we are working with, because you see, we cover quite a big area, the whole of Coast Province, and we cannot have, the in-house counsels cannot handle matters for everyone in the entire Coast region. So what they do is that we also have the panel of pro bono lawyers who we work with to enable us enhance access to justice to our clients. So we also do public interest, strategic public interest litigations on matters of public interest. Why are we specifically interested in the vulnerable? Because these are people who cannot, most of the time, defend themselves. As you've seen, access to justice, we refer to Article 48. Article 48 says that all persons are entitled to access to justice, and that if there is any fee that is required, then it shall be reasonable and shall not be an impediment to justice. These are people who are not even able to get the money to pay for those legal fees. They are not even able to get transport to access the court premises, and especially more during the COVID period when most courts went virtual. So most of them, you see, if I cannot even afford a meal, how can I afford a gadget to log in and handle my matters? So we are interested with these vulnerable people because they are people who do not have the resources, and they are people who cannot also defend themselves. And the vulnerable include people living with disabilities, there are people living with HIV, children in conflict with the laws, minors, consenting minors having consensual sex, and then we have teenage mothers, single mothers, widows. So those are the people that FIDA really advocate for their rights in terms of access to justice. Thank you.
Beator.
Thank you very much, Dr. Kinyanjui. My name is Viola Yator. I am a magistrate Tononoka Children's Court. And as you understand, it is the only children's court in Mombasa County. And countrywide, we have only 2 children's courts. That is Muangi Children's Court and Tononoka Children's Court. Specifically, what the court handles are cases that are listed under Section 73 of the Children's Act. Just to mention a few are maybe cases related to custody and maintenance, guardianship applications, protection and care cases, children in conflict with the law, and other miscellaneous applications. So at the court, because the topic of today is access to justice, what the court has done in conjunction with the judiciary as a whole is to offer free legal pro bono advocates to all children. So I'm happy to report that as we speak, even as at today, as we speak today, all children who are in conflict with the law, all of them are represented 100%. So we have, the pro bono lawyers are paid something small, a token of appreciation from the headquarters, that is Nairobi. And basically that is what is happening here. And for the custody and maintenance cases, 3/4 of the people who come there, especially women, 3/4 are self-representing, with most of them maybe trained on how to represent themselves by FIDA maybe, Clear Kenya, Kituo cha Sheria, and all other organizations that help women and children. So maybe as we move forward, we will be discussing more. And I think that is it for now.
Yeah, thank you. Mr. Maku. Yeah.
Thank you, Daktari. Good afternoon, members. My name is Nick Maku. I work with the probation department. The probation department is mandated to manage non-custodial sanctions. And as guided by Daktari, why women, children, and persons living with disabilities? My take is that from a criminogenic assessment, these are persons with special needs. And as a department, we handle them differently because of their needs. We must do assessment, identify with them, and come up with individual treatment plans for each. Now, as a department, we have our core functions. One is submission of different reports to court, Power of Mercy Committee, Board of Visitors, among others. We also rehabilitate, reintegrate, and resettle persons placed on non-custodial sanctions. Now, of importance is the quality and timely submission of reports to enhance justice to those that are in conflict with the law. And I think I will take up and stop at that stage as of now. Thank you.
Thank you.
Thank you. My name is Gabriel Kitili. I'm a coordinator of Children's Services here in Mombasa. And our mandate is to protect children. You know, the government has that mandate to protect vulnerable groups. And one of the vulnerable groups is children. As one of us has said, children are vulnerable by the fact of that they are underage. There is tendency of some cultural practices and also grown-ups to undermine the rights of the children. And that's where the government comes in to protect these children. Because even some cultural practices, they don't respect children's rights. Especially the issue of participation. Many adults make decisions on behalf of children without consulting them, without seeing whether the implications of their decisions and to see whether those decisions are going to affect the children negatively. And that's where we come in. We operate under Children's Act 2001, which is also under review, and under Section 119, it talks about children who are in need of care and protection. So any child who is in need of care and protection is under our mandate to protect them. Thank you.
Thank you, Dr. Arik. Good afternoon. My name is Jemima Kutata, Miss President, Mombasa County. I work with the Association for the Physically Disabled of Kenya as a resource mobilizer. And today I'm here representing Juliet Rua, National Council for Persons with Disabilities, because I'm also a disability mainstreaming trainer. National Council for Persons with Disabilities is a state body which was initiated in 2003. And as we can remember, that particular time is when our dear President, Kibaki, was on a wheelchair. Because for a long time, the issues of disabilities were shelved on the shelves. There was nobody was talking about disability policies or anything. But when our president went on a wheelchair, is when he realized the challenges that persons with disability goes, and that is when we got the 203 Disability Act, which now is being executed by the National Council. The National Council with Disabilities mandate is to do the registration of persons with disabilities, and we have different programs. We have the cash transfer for the most severe children with disabilities. When we talk about the severe disability, we mean those children or people who need 24/7 care. And also we have a development fund where we give persons with disabilities grants to start income generating activities. And also at the council, we have the LPO financing because of the 30% procurement entity, so that our people with disabilities can also be able to participate when it comes to public procurement. And before I finish, I would like to do a polite correction. We are not persons living with disabilities. I know newspapers, everybody in the house talks about persons living with disabilities. I like making that correction because I see it on the paper, on the media. We are persons with disabilities. We don't live with disability. I am a woman with disability. I live with my friends, I live with my colleagues like you, and I live with my family. So get that correction and correct others, because even in the article, this like writing persons living. Leo mtoa hiyo living, eliminate it completely. We are persons with disabilities, children with disabilities. Thank you.
Much for that correction. In fact, when we did the training where we had people from your organization training us, we learned a lot. Sometimes you add the living thinking it's a better term, but it's great to just hear directly what actually is the acceptable term. So, and you've talked about very many gains. Really speaking, hearing you speak, it sounds like we've made a lot of gains in the justice system with regards to these persons with disabilities. Are there challenges, and what are the key challenges? Perhaps speaking about two challenges each that you think are key for those that you represent. Start with Mr. Joram again.
Hello. Yeah, thank you. I'll mention challenges briefly. Mostly when clients come to our office, first we organize for mediations. Then if the mediations fail, is when we prepare them to go to court. Now, at the point of preparing these clients to go to court, to go and represent themselves, most of them are illiterate. So educating a person who does not have some form of education to go and represent themselves at the court is a big challenge. Two, at our office, we were not prepared. Even now, we are not prepared to handle people with a disability where they are deaf and dumb. So when this group of people come to our office, it's a big challenge to us. We have to source assistance from elsewhere. Then the high expectations from the community. Since you mentioned, you said we do only 2, because I have many. Let me stop at that.
Yeah, and perhaps to ask Honorable Yator, so that we go thematically to talk about challenges relating to children, building on Joram's presentation.
All right, children face so many challenges. First of it is especially on the issue of defilement, the sexual offenses cases. The biggest challenge we have is the kangaroo courts at the village level. It appears some people have decided to be judges in the villages, and whenever something like that happens, they are not reported, and that child ends up not getting any justice at all at the end of the day. So that is the main challenge, and that challenge we realized we realized that there are such challenges when we went for radio talk shows with our CUC members, and we realized that most of the time the community decide to solve the issue at the local level, not knowing that a child has been violated, and that child, apart from being violated, requires some form of counseling, maybe after, what happens after that. It's not only a matter of the two families settling the issue together, they have to go beyond that. So you get most of the time that these children will end up, because of that issue not being addressed, they will end up maybe running away from home, and maybe getting defiled in the process again by other people. So, and we lose that child just like that. So the issue of kangaroo courts is it is actually, it's a challenge to access to justice to this vulnerable group, the people who cannot speak for themselves. So the other issue is where the perpetrator is a family member. It becomes extremely difficult for those people to report. And they keep quiet, or they relocate to maybe some other towns. For example, if they were living in Mombasa and maybe an uncle was the one who defiled the child, that family, the family that their child was defiled, always end up relocating to other places. And that case disappears like that, whether it had been reported or not, because of intimidation and fear. So in that regard, that child will not access justice at the end of the day. So with regard to custody and maintenance cases, there is also a challenge when it comes, the challenge of poverty. Most of the clients who come to our court are women. Most of them are the plaintiffs in that regard. So when they are not able to, thankfully the judiciary waived recently filing fees for custody and maintenance cases. These women are coming on behalf of their children. They are not coming on their own behalf. So if they are not even able to draft those proceedings, sometimes they are not aware we have organizations like Clear, FIDA who help them. So by the time they come to court, they don't even have that fare to come to Tononoka court to seek for help. So sometimes as a court, we also do some fundraising to assist them with fare to go back. Some of them come as far from Kaloleni, Mariakani, and they only know that if they come to a children's court, they will get assistance. So that the issue of poverty is also a very great challenge to access to justice by the vulnerable, that is women and children. I think those are some of the challenges. Maybe Jen can, because she works for FIDA, she can add.
Yeah, sure.
Yes, the greatest challenge that FIDA experiences working with the vulnerable groups is, number one, is access to our offices. As we have said, that we represent clientele across the coast region, and you find that we only have one physical office, which is based in Nyali. So you find that we have clienteles coming from Gasen. And these are people, as we have said, vulnerable, low income earning, and very illiterate. So you want to tell someone to spend almost 2,000 shillings coming all the way from Gasen to your office just to report, to complain over an issue or a case that they have so that we can take it up. So getting those people coming and accessing our offices is quite a challenge unless we go to them, and we know this is a donor-funded organization. Sometimes if you don't have the funds, then that means that we are incapacitated, so we are unable to reach out to that rural woman that is in need of our services unless they come to us. And them coming to us, meaning that is not good for their pockets because they don't have the money. And another thing also is we don't have, reaching out to pro bono lawyers, we don't have enough people, advocates, giving themselves out to take out these pro bono cases. Another challenge, as I was speaking to one of these, the doctors who testify in court, and they say that, you see, sometimes we come to court and we sit there for long and we are not reimbursed the fee that you are supposed to be for attendance. They're supposed, as witnesses, I think they're supposed to be reimbursed. So they are not given that money in time. So that discourages them, and they are saying that, in fact, most of the time they feel that they don't even want to handle matters, files that are going to court, because they know they're going to spend so much time in court, and they are not going to be reimbursed for the time and the period they have been to court as is expected. And also access to the courts themselves. Sometimes you find, say an example of Hola, we have a court in Hola, but you see a litigant has to come all the way to the interior areas. So, and the mode of transport there, they don't have matatus, they don't have, the only mode of transport they can rely on is the motorbike. So these motorbikes, they tell you that I will charge you 500 shillings to Hola Court and 500 shillings back. That is almost 1,000 that they have to spend to access the courts. So they experience quite a number of challenges. And another issue is now on the sexual and gender-based violence cases that we experience. You take up those cases, but you see now when it comes to the actual now presentation of evidence, there's quite a challenge, especially on matters of forensic analysis of those evidence. We don't have an effective government chemist that will enable, because we know most of these sexual and gender-based violence take place in privacy. There's no eyewitness that will come and say that I witnessed this person being defiled or this person being raped. So most of the time you rely on the forensic evidence, the clothing, the semen, and the DNAs. So we don't have enough government chemists to analyze that evidence and have them presented in court. So that what we see is we just go to court with the panties and say, you see, even the panty is soaked in blood, the panty is soaked in semen, and yet there's no evidentiary value in that that has been analyzed from that panty to show, and even the accused person has not been taken through DNA process to have that nexus between that evidence and the actual, that he is actually the person who perpetrated that kind of violence. So there's quite a lot of challenges in the clients matters that we handle and the clients.
Thank you. Mr. Kitili, what specific challenges do children face that probably haven't been said?
Yeah, the biggest challenge which you are facing, especially in the community, is the family disintegration. When family are disintegrating, the most victim is the child. And if you look at the cases we handle, the major case category there is neglect, followed by custody, and then child offenders come number 3. that tells you it's an issue of family. So if we can keep our families and try to keep our families intact, then children are going to be safe. Families is very key for children protection. And the other one is the community. The community. We need everyone to watch and look for where there's an abuse, we report it. But the community is not reporting, just looking at issues of child abuse going on. And when there is a report, it's when it is too late and the child has suffered a lot. So that community apathy is there. The serikali saidia medarity, that you are there, you are seeing a child being abused, but you want the government to come down there, but it doesn't know. Unless somebody reports, then that child will continue being abused. So,
Mr.
Thank you, Dr. I want most of the things have been said, but there is abundance of drugs in the slums and in this county and in this region, and it is affecting the children and women also negatively. Majority of the gangs, as juveniles, we handle initially have access to drugs, and they graduate to gangs, radicalization, and those that are now engaging in terror activities. Two, we have wanting environment, especially for children. Children living in pain and without support systems. I would pray that you visit the slums and you go even to the children's court and accompany the people you see there, the mothers and the children who are being in conflict with the law, and go to see the environment they live in. It is a wanting environment, very wanting. So I think it is time with the civil societies and agencies came together to improve the status of individuals. I'm happy that the government has interventions like the women groups that are being funded, and also availability of businesses now and jobs in the government entities. So environment is also wanting. He has mentioned dysfunctional families, and in this region, divorce is a common issue, and it leaves families and children in a state of vulnerability, and majority of them end up engaging in crime because of the push factors. So it is time we modernized those many talakas that are within this region. Thank you.
Jemima?
Thank you. When it comes to disability, disability goes hand in hand with poverty, because some disabilities are due to poverty. Sometimes you get somebody who is blind because the parents could not take that person to the hospital, and that led to cataract, and sometimes they end up getting blind. And also when you talk about disability, the stigma in it is a big challenge, because when a child is born in a family, that kid, most of the time, the child is hidden from the society, from the family members. And there are places when we go, like in Kilifis and Kwales and wherever we go, you find that the child has already known that she's not supposed to meet with people. Once they hear our vehicle, the children goes behind the bed. So you can imagine that stigma of that child when she's born. She does not interact with anybody until when she gets an intervention with the organization that deals with disability, and then those kids are brought out. One, those kids can't socialize. That's a challenge for those children and even the adults. And you find that most of the time people think people with disability are not like other people. They think people with disability can't do anything wrong. They're not entitled to any rights. You find that there are people who live with their people, but they don't give them even an opportunity to make a decision on their own. Even when it comes to clothes, you find that somebody else decides for you what to wear. And when now it comes to access to justice, the greatest barrier is the attitudinal barrier. Because one, when you want to report a case, one, there is accessibility barriers. Most of our institutions are not accessible. When I talk about accessibility, think of that person on a wheelchair. Is your office accessible for them? Think of that slippery floor, that when Jemima comes to your office, how will she access? Some offices are very slippery. You can go there and even fall. And when you talk about the attitudinal barrier, there are people, when you go to their offices, when these persons with disability visit their offices, they just want to keep away from them because they can't communicate with them. For example, if a deaf person comes to your institution, you don't have a sign language interpreter. You don't know how to talk to that person because she has not even gone to school to know how to read and write. So sometimes they are put off, and most of the time their cases are not put into consideration. Another barrier is the communication barrier and information. Most of our people, because of their background and also the African culture, for now, I can see many persons with disabilities are going to school, but those who were born in 1970s and 80s, most of them, they never went to school. They never got that opportunity to go to school because most of our school in the rural homes, if you can think where you come from, the schools were very far away. So you find that even for them, because of the illiteracy, accessing information like reading and writing and understanding of how they can write an appeal is not there. And there is lack of that opportunity even to have a public forum where they can be taught on their rights and where they can understand how they can report the legal processes. And then we have the economic status, which is, we have already talked about poverty because it always goes hand in hand with disability. And in the types of disabilities that we have, because when people hear about disability, they think of the physical one. If you see somebody on a wheelchair, or rather you see Jemima on crutches, that is the disability most of the people know. We have invisible disabilities. There are people who can walk here, but you can't tell whether they have disability or not. So we have to be careful when we are handling issues, because you may be dealing with a person with disabilities and you maybe think that they are pretending. For a good example, some few years back, there was an issue of deaf people who work around our Mombasa post office. If most of you have interacted with them there, they were caught by the police, and one of them was really beaten because the police was telling that guy, wewe ni mjeuri utaki kuzungumza. They didn't know at all that that guy was deaf and he has been operating near the post office until when we intervened, but the guy was already hurt properly, and that was lack of sensitization to the police to understand that we have some invisible disabilities. And when you talk in the same context of the information and communication, somebody like a visually impaired person, most of our information are not provided in brailles or large prints. And sometimes we say we are compliant, we have complied with disabilities, giving information. Are our websites disability friendly? Do we have large prints for people with low vision? Do you have braille? Is our information brailled? Do we have sign language interpreters in our institution? Those are the greatest challenges. And 49% of persons with disability have intellectual and psychosocial disabilities. And those have really suffered severely because when they have those psychosocial issues, most of the people, even the community itself, does not understand it. Most of them, they say ni wenda wazimu, but it's not wenda wazimu, it's a type of disability which many people need to understand. Thank you.
Yeah, thank you, Jemima. And one of the reasons why we have this colloquium is also to inform programming. So we'll come back to the panelists so that they can tell us what are the urgent interventions that they would propose. But before we do that, I'd like to open to plenary 3 questions, and then we will get back to them to wind up as I speak about the interventions.
So my question goes to Honorable Yator. Jen has mentioned this as a challenge for them. So how do you resolve a case where you're sure of that an incident has taken place or a violation has taken place, but you don't have enough evidence, especially when it comes to cases of defilement?
So we'll take the questions. Yeah, there's somebody.
My name is Vivian.
Oh yes, Vivian.
From
Proceed,
ODP.
yes.
So my concern is with respect to issues that have been raised with Jemima. Mine is, number one, an observation as to the attitudes that we have towards people with disabilities, especially in the criminal justice system. We have advocates, we have prosecutors, we have victims, we have complainants, we have accused persons. Generally, what is your attitude when you're told that's the advocate who will be representing the person who has disability and the advocate also has disability? The first impression is that as a prosecutor, you would imagine that justice will not be served if that goes ahead, if that goes on. So you would insist that maybe they should get another advocate. And so mine is, we really need a lot of sensitization around issues of persons with disability. You find that a lot of them have some very good information that would assist towards ensuring that justice is achieved. But the problem that is there is a matter, I'll just give an example of a matter that was being handled by one of the prosecutors. And you realize that vulnerable people and children with disabilities, they are prone to abuse, and especially sexual abuse. But a lot of times, and I was quoting a particular matter where we did not want, the prosecutors were not so keen on listening to this child who had been defiled because that child was deaf and dumb. But the person who was trying to interpret what the child was saying, fortunately this child knew how to write. But you see, as we were trying to do that pre-trial conference, we were putting a lot of reliance on the intermediary who's supposed to explain to us what the child is saying. But the child kept indicating that that information is not accurate. So I want to agree with Jemima that let us also be very open-minded when we are dealing with people with disabilities. Let us not just assume that they are mentally not competent and they do not know what is happening around them or what is happening to them. Let us be very open-minded. And I like the challenge that has been posed, that even as we disseminate information from the various organizations, do we have information that is friendly to people with disabilities? So thank you so much to the panelists.
Okay, I'm still Evans. Mine is to interject first, then I ask a question. Okay, from the word go, like for example, yesterday my take home was for us to access justice, there must be a collaborative element. And I want to thank the panelists that they are like-minded fellows in terms of as far as child protection is concerned. So I want to ask Honorable Yator. I'm a member of Shanzu CUC. I have not interacted with the Tononoka CUC. But I want to ask if there is any plan in place to reach out to the community and sensitize them on issues affecting children, like how court conduct its procedures. I know there is a big challenge currently on children in conflict with the law and children in need of care and protection. Is there any plan in place? Second, the timeline to handle some of these children matters or cases before your court. We know that children issues are they are emergency in nature, and timeline is a real concern. Lastly, I want to remind our dear Jemima that there is no disability, and the only disability we have is a negative attitude. So let's encourage our members that it is high time to take their spaces and give out their voices. Thank you.
Yeah. Thank you. Allow me, please, to let the gentleman behind to ask the question.
Hello, my name's Mr. Yusuf Nyaga Kanyifa, and I wish to ask a question to the panel ahead of us. The question goes like this: you deal with illiteracy people taking their claims and complaints of molestation to a police who is also not really adequate trained to present an issue to a judge who is highly trained and able, and you want to meet and get a justice. How do you overcome the imbalances?
So thank you very much. I think questions of prosecution and the developments there in court, but allowing you to answer the questions. You can take the mic. I think we can start with Honorable Yator. You had a couple directed to you.
Yes, thank you. Let me start with the timelines in handling children cases. We have children practice directions that require us to handle children cases within 6 months. But sadly, it's not possible, it's not achievable. Why? Why it's not achievable is because being a special court, for example, when it comes to children in conflict with the law, most of these children are school-going children. Some of them are in boarding schools. Some of them maybe are not within Mombasa, maybe far away. So the challenge comes in when we are fixing the matter for hearing. So we get information most of the time that the child is away in a boarding school, maybe in Makueni, maybe in Eldoret, maybe wherever, and their attendance cannot be procured. So in such circumstances, we fix that matter only when schools have closed. So the 6 months timeline is not possible for all the cases. But where the children are based in Mombasa, we try as much as possible to clear that case within 6 months. And also with regard to very young children, maybe the victim is a very young child, maybe 2 years, 3 years, because we cannot meet the timeline, the 6 months, what we have devised as a court is to hear the evidence of the child first. so that they don't forget. So we normally give a very near date for the child, for the victim, maybe within 2 weeks, maybe 1 month. And then after that, now we can take a convenient date for the other witnesses who are adults. So the issue of time, it's very tricky for us. And I'm sure also to most of my colleagues. And on the issue of whether we have any plan to reach to the community, to explain to them maybe court processes and everything. We have plans as a CUC, as Tononoka CUC. I don't know if you've been listening to radio stations. We've been engaging the public through media by having regular talk shows where we get questions from wananchi and we answer them. Secondly, we have been having our open days. And in 2019, we had one. In 2020, we had another one. In June 2021, in conjunction with Nairobi University of Nairobi, we had a legal aid day at the court. And recently, on 15th of February, we had again another legal aid day. So we have been doing something with reaching to the members of the public. And we are planning to have many, many more to come in future. And then there was a question on where there is no evidence in a criminal matter. For example, like my Jen here addressed the issue of DNA. So as a judicial officer, when we are hearing such cases, there are only 3 things that are required to be proven by the prosecution. They have to prove the age of the victim, the positive identification of the perpetrator, that is the accused person, and the evidence of penetration. Once that is proved beyond reasonable doubt, that is a straight conviction. So the issue of DNA only comes in where the identity of the perpetrator is not known, or there is doubt as to the identity of the perpetrator. That is when now the issue of DNA comes in. Otherwise, where the victim maybe knew their perpetrator. For example, most of the victims know their perpetrators by their names. Some of them are relatives. We don't need DNA in such cases. So it is on a case-to-case basis. So we don't just say because DNA was not done, it is an acquittal. No. It depends on the evidence in totality, what is brought before court. But of importance to note is every person, every accused person is presumed innocent unless proven otherwise. So where there is evidence, we convict. Where there is no evidence, we acquit, sadly. So if I got another question right on the issue of illiteracy, where there is a gap between the people who are handling the cases and the people who are coming to court. From my side, I think the issue of illiteracy does not come in because we conduct our proceedings in a language that is understood by everybody. So where a litigant comes to court and they only understand Kiswahili, that will be the language of the court. Where we have a litigant who cannot speak Kiswahili, who cannot speak English, we use the local language. We look for an interpreter who will interpret to the litigant in that language they understand. So the issue of illiteracy doesn't come. And for the children's court, it is a court that we don't follow procedures. You can even come in form of a letter. You can even write your application in Kiswahili, we will admit. You can even talk, just talk. You can come and give your defense. Most of our clients come to court. they don't file anything, but they come, we record their evidence, and they are subjected to cross-exam, and we give a judgment. So that is from the perspective of the children court, but for the other courts, of course, they have to follow the procedures. Thank you.
Yeah, thank you, Honorable Yator. Yes, but also, and I think the other one was on disability was a comment, not a question, so we'll hear you, and then we have the parting shot.
Yes, I would like to add something to what Honorable Yator has mentioned in regard to timeline on children matters. Remember, in the children's court, we have the criminal justice and also the civil justice. And so she has mentioned about the criminal justice, and then in the civil justice system, children cases, I think the court has done very well. In most cases, they have been giving orders within the shortest time possible. There have been urgent orders which have been given even within one day or 2 days or 3 days. Cases have been it's not very easy to finalize a civil case within a limit of time, because the needs of a child, when you get to the court, when a child maybe is 2 years or below, that child, when they get to 10 years or 15 years, the needs change. So you have to go back to the children's court. So that case will remain open as long as that child has not become an adult. The court will remain open for any issue, for any revision of that particular case. However, judgments have been issued within 2 months on cases subject to review when situations change. And also on the issue of creating awareness to the community. In Mombasa, we have what we call Mombasa County Children Network, so Children Network, so Child Rights Network, and we as a network, we've been joining hands to create awareness in the community on child protection issues. And so, the Tononoka Children's Court is among the members, the stakeholders of the Mombasa County Child Rights Network. And we have covered a lot. We have gone to the schools, we have gone to the local communities and beyond, not only within Mombasa, beyond, especially within the 3 counties of the coastal region. And so I think we have done a lot in regard to creating awareness and also having matters settled within shortest time possible.
Yeah, and we could hear your parting shot as well as we go to Jane, as you answer, and your parting shot.
Yes.
I'm alerted that we've overshot time, so just give a parting shot, and Jane, you'll answer and give yours as well.
Yes. There is we have the new technology, using the Zoom meetings to deal with cases at the children's court. The technology will achieve a lot if we have the community educated on the operation of the technology, and also at the same time the members in the justice actors, the players in the justice actors, sometimes you get frustrations from your fellow justice actors. So I would say we all team up hands to understand which the other person is doing, and we complement each other in doing what we ought to do to achieve the best interest of the child. So joining hands together to do the right thing instead of undermining what the other actor is doing. And so let's enhance what is there already, what each player is doing, we complement each other and we try to share information as it comes by.
Yeah, thank you. Very important contribution. Jane?
Just to answer the question that my colleague had asked on how we create the balance between the illiterate person who doesn't know how to present the evidence and the very qualified judge. What FIDA has done is that it is doing a lot of training on the actors in the criminal justice system on investigation and prosecution of criminal cases. And we have trained quite a number of the police officers, the ODPP, and all the actors that we feel are engaged in the criminal justice system on matters investigation and prosecution of such cases. And also, we have told you that we have a pool of pro bono lawyers and in-house counsels, so that when those matters come to court, at least we have a counsel who will be representing the victim in such cases, so that they're aware of the procedures and the processes that are supposed to be undertaken, just in case the prosecution will overlook certain evidences, then they're able to tap into and also make their own presentations on behalf of the victim. And also, we have been doing a lot of legal aid on matters of the criminal, on how to handle such criminal cases. And also when these cases go to court, there's what we call the pretrial conferencing. So we try as much to make sure that before the actual hearing, there is that pretrial conferencing that is done, so that they're aware that how many witnesses are in this case and what is their evidence and how are they going to present that evidence before court. My parting shot would be that as actors in the access to justice, we need to collaborate, as Joram has said. Let us not be seen as competing. And also, we also need to implement. I've always said, even in different forums, that we have very good laws that if strictly followed, then we do not be talking about these challenges that we are facing. For example, you see now we are saying that we have enrolled the sexual and gender-based violence courts at Chenzi. But are those courts well equipped? Do we have enough prosecutors specialized to handle such cases? If you look at, Alan said here yesterday that we concentrate so much on election petitions in such a way that we give them timelines within which they're supposed to be completed. Why can't we also have timelines within which those SGBV cases are completed? And sometimes you see, you get a child into the criminal justice system too much that sometimes when the actual time of the hearing comes, the evidence seems to have been, they seem to have been coached. So that when Honorable Yator listens to this child and the way they are flawless, they feel this child has been coached. But it's not the case. It's because you've taken this child through the criminal justice system for long. Each time the case comes up, they have to be prepared. They have to be told this is the what, to be reminded that this is what you actually recorded. So we need to really implement. And then also this issue of, we are saying that we do not have enough rescue centers and all those things. But if you look at Section 114 of the Children Act, it has a robust orders that we can take advantage of to the benefit of the survivors of the sexual gender-based violence. Most of the time we rush to take this child to the victim or the survivor to a rescue center. Why don't we make use of that exclusion order, so that if it is if it is a matter of incest, then that father or mother that has committed that particular offense be excluded from that family, instead of disorganizing the life of this child. You know, when you take a child to a rescue center, you've really disorganized them. If they're used to bread and butter in the morning, then you take them to a center where now they have to eat githeri, then that already you've really disorganized. And then when you leave this man in that house, I'm not saying it's only men who are perpetrators of violence, but I'm using it as an example. If you take this man, if you leave this man within that house, let's say that is a family of, say, 5 people, 5 children. What makes you think that this man will not go for the other children who have remained? So what if we make use of those exclusion orders, instead of having to rescue this child, then exclude this person, and we have those exclusion centers where we take those. Most people will argue that this is a breadwinner, so we cannot exclude them from, if we exclude them, then how is the family going to get their daily bread? We can have those exclusion centers under strict circumstances, allow them to go to work, make sure the amount they get, we facilitate the families so that their lives moves on in the period within which the cases are still going on. So I've always said we have very good laws, but poor on implementation. So let's work on implementation.
Yeah, thank you very much, Jane. Parting shots.
Okay, thank you. In addition to what Jane has said on the exclusion orders, we can also, the investigating officers can utilize, can swear an affidavit to that effect that the accused person be denied bond until maybe the victim testifies. I think that is another way of ensuring that we don't remove our children from their homes. And my parting shot would be, let's just collaborate as actors in the justice system to make sure that the vulnerable access justice. Thank you.
Thank you.
Thank you. I want to state that all cases referred to us, and especially for children in conflict with the law, we explore all the options available, and institutionalization is the last resort. Two, I would ask that we improve on our institutions' confidence, that we have the public confidence in our institutions, for the community to have trust in dealing with us. But the institutions will remain, and as we are seasoned. Thank you.
You.
Okay, for me, I would want to call upon each one of us to protect our children. Children's protection needs each one of us. When you see an issue, when you see a situation which may end up in child abuse, please intervene, then report. We usually talk of spot it, stop it. And if you can't stop it, report it so that others can stop it, please. Then the other issue is about family disintegration. Would want maybe religious leaders to help us in this, that divorce does more damage than just advantages. So when family stays together, it is an advantage to the children. I know this one is an issue of a religious issue, but generally divorce affects negatively to children. And if there is a divorce, please, whoever is presiding a divorce, make sure that the children's issues are well handled, such that you don't just give divorce and then the children are left hanging.
Thank
then
you.
The last and not the least is that as a government department, we are aware of the fact that prevention is better than cure. And we are coming up with a program called Care Reforms. This program is aimed at preventing child abuse, and it focuses on the community, especially family. We are going to do with family strengthening, psychosocial support, and all that to keep the family together to protect the children. Then the other issue is we have come to the fact to know the fact that children in the institutions, they also suffer a lot, especially emotionally, and we are saying, all of us, let us join together and retain children within the community.
Yeah.
If the children in the families are not, the family environment is not conducive to the child, we can have an alternative place, for example, fostering, guardianship, there's also kinship adoption. So let's try to keep children in the community rather than just taking them to the institutions, because institutions, children suffer a lot, especially emotionally. Then the last.
Mr. Kitili, thank you very much. We've overshot on time. Unfortunately, Jemima, yours has to be very short. I'm being alerted about the time, but over to you. Please, your parting shot.
Thank you.
Conversations will continue.
Thank you. My parting shot this afternoon is disability is a club. that each one of you is a candidate here. If you don't join it now, the age is catching up with you. When you reach 70 years, 80 years, you will need that wheelchair. You will need that crutch. So because we are all candidates of disability in one way or another, let us embrace disability. Let's make our institution and even our homes a place which is accessible. Because that bedroom of yours you have built in your topest story building, when the edge catches with you, you'll not be able to access that bedroom. So think about accessibility and embrace disability. And above all, let's have assistive devices in our offices. Most of our institutions, they don't have wheelchairs. When we come to your offices, some of the persons with disability are crawling. So it's very important for us to have wheelchairs in our institution and assistive devices. And also, let's embrace disability mainstreaming. National Council for Persons with Disabilities offers trainings on disability mainstreaming. I am a disability mainstreaming trainer. If you need that service, you can get in touch. We will come, we will train your staff, we will train your institution so that it can be able to comply with disability. And nothing about us without us. When you're doing your programs, always remember to include persons with disabilities, to put their voice and tell you what suits them. Don't decide for them, give us a chance. Thank you.
Thank you. A great way to end. Thank you, panelists. May we give them a round of applause. And thank you, participants, for your patience. We have overshot. It's now 2:05, and we do have one last session. Today is Friday. We would like not to stay too long. I kindly request that we are back at least 2:45 so that we are able to end in good time. Please, we seek your indulgence. Let's have lunch quickly and be back for the last session. I believe you already have your lunch tags. Have you received your, if you have, yeah, thank you. Welcome for lunch, and thank you, panelists. Promise that there will be a couple of people from the community who will, I'll give a few minutes after this session to say something. Kwa hivyo sijawasahau, mtazungumza hivi karibuni. But I'd like to request the panelists for this session to come up. Starting from ODPP, and then we have NLAS, Huria, and we deliberately had this session at the very last, because and as you have seen, it keeps coming up. It's a concept that's really important in the justice system now, but it's also one that we should be able to have a good conversation about this afternoon. Yeah, so a lot of the panelists throughout the symposium have been saying AJS, ADR is the way to go in the justice system. So this afternoon we get to hear, is it really the way? Are there limitations? What are the interventions that are required? But before we do that, please introduce yourselves. Start with Daktari.
Good afternoon, ladies and gentlemen. My name is Francis Karaoke. I am a lecturer at Strathmore Law School and also the director for Strathmore Dispute Resolution Center. And in my private time, I do practice arbitration, mediation, and consult on alternative justice system. But here, I also came in a different capacity because I'm an associate director of the Human Rights Agenda. Thank you so much.
Thank you. So we're in the right hands, AJS expert.
Good afternoon. I am Mutegi with the National Legal Aid Service.
My name is Kambaga, Vivian Kambaga. I'm a prosecutor. I am in charge of the High Court prosecutions at the High Court and prosecutions in the Court of Appeal. I'm the deputy to the regional coordinator. And I, like my colleagues who've spoken before me, I wear many hats. I'm also a champion of alternative dispute resolution mechanism methods. And for that reason, I'm happy to be here just to add my voice to this discussion. Thank you.
Good afternoon. My name is Nicholas Ndavera. I'm a former convict. I've been in prison for the last 1 year, and I'm a beneficiary of Huria. I'm glad to be part of this panel.
Just to start us off, there are a couple of terms that we keep using interchangeably, saying AJS, saying ADR, Daktari. Please clarify them for us so that we start on the same page.
Thank you so much, Dr. Sarah. I think the two terms that we have used quite loosely in this session since yesterday is alternative dispute resolution mechanisms, ADR, and alternative justice systems. And I'll try to explain who they are. So ADR basically refers to all those mechanisms for the resolution of conflicts or disputes outside court. All those mechanisms that are used by parties in the resolution of their disputes or conflicts outside court are called ADR. Of course, the mechanisms that form part of ADR are quite many, and our Article 159(2)(c) of the 2010 Constitution clearly outlines the ADR mechanisms. We normally start off with negotiation. When parties cannot or they have a dispute between themselves, the first port of call when it comes to a dispute or conflict is to negotiate between themselves. So negotiation is the first port of call. And we do negotiations daily. We do negotiations on the road. When you want the right of way, you do negotiations. So it is the two parties who are speaking towards each other to try and find a solution to the problem they have. If they cannot come to a solution, there is an impasse in the negotiation, we normally call in a third party who is called a mediator, who helps them in breaking the impasse or the deadlock that the two disputants were not able to unlock. So that's when we have mediation. Basically, mediation is the involvement of a third party who helps the disputants to resolve their dispute. And the work of a mediator is basically to facilitate. The mediator does not determine the dispute. He facilitates the negotiations that had stalled between the two disputants. Another mechanism that is similar to mediation, but not mediation, is conciliation, which is used commonly in the employment labor context. And with conciliation, just like mediation, but the slight difference is that a conciliator can make a decision, for the parties. Apart from mediation, we also have arbitration. And arbitration basically is a mechanism whereby you have a private judge of the party's choice, helping them to determine the disputes that they have. Please note the difference between arbitration and litigation is the fact that in arbitration you have a private judge who has been appointed by the parties themselves. And the private judge can be appointed in the commercial contract, in an employment contract, in that supply of goods contract. So it was quite disturbing for me when I heard a panelist mention that they are doing arbitrations and they are appointing arbitrators. So an arbitrator has to be appointed by some contractual documents. And of course, the history or the provenance of arbitration is that it developed, or the arbitration we are practicing developed from the West. And that's why it applies mostly in commercial context. But that is not to say that it doesn't have origins in the African context. We were practicing arbitration, but it wasn't referred by the term arbitration. From arbitration, we have other mechanisms such as statutory adjudication. Statutory adjudication is a mechanism for resolving construction disputes. disputes in the construction industry, they are resolved through adjudication. Adjudication is a more time-bound mechanism for resolving disputes, because construction disputes, there are many issues of cash flow, and the parties there want the monies to flow from the employer to the contractor, subcontractors, etc., etc. So we use adjudication. In Kenya, we don't have a legal framework, but we tend to use the dispute adjudication boards, and they normally provide for a time of 45 days within which the dispute should be resolved. And then there are others, expert determination, where you have an expert, a valuer, somebody who is an expert in wine, who can come and value or assess and make a determination. So expert determination is another mechanism. Another mechanism is reconciliation, is also provided for in the Constitution, 2010, but there is a history there because the drafters of the Constitution were thinking of conciliation, but then in the final draft of the Constitution, they wrote it as reconciliation. So reconciliation is a process whereby the parties are brought together, they are reconciled through a third party who helps them to speak to each other. So those are basically the main mechanism: negotiation, mediation, conciliation, arbitration, statutory adjudication. They are the most common mechanisms for resolving disputes through ADR. When we talk of alternative dispute resolution mechanism, which is also provided for in the 2010 Constitution, the alternative dispute resolution, the alternative justice systems is actually a term that has been popularized by the alternative justice framework policy, which was actually engineered by Professor Joel Ngugi. So, but the term that the Constitution uses is traditional dispute resolution mechanisms. And what does AJS mean, or TDRMs, or African justice systems, as I prefer calling them? These are all those mechanisms that African communities have used in the resolution of disputes and conflicts since time immemorial. And the genius of the 2010 Constitution in recognizing this mechanism has really helped in ensuring that we recognize locally acceptable, legitimate mechanisms that our people have that are able to enhance access to justice. I'll be saying later on that, in my view, the people-centered mechanisms for resolution of disputes have to be mechanisms that are culturally appropriate, culturally familiar to the people. And I believe AJS are the mechanisms that can do this. These are the mechanisms that are used by our communities, the Mijikenda, you heard the judge yesterday, the Jurinjeke, and all the other communities in this country. And so it is important to note those distinctions. But within AJS, we also have arbitration, although it's not called arbitration. For example, the work of the Jurinjeke, what they do, or the elders at here in Rabai, what they do there is a form of arbitration, but we don't call it arbitration. Also, other times they use mediation, they use negotiations, but we don't call them as such. So basically, those are the mechanisms that we have and the differences between them.
Yeah, thank you for providing clarity on the use of those terms. Vivian, traditionally we believe the prosecution's job is really just to prosecute and obtain convictions. That's our old traditional understanding. But you're here now to talk about AJS, or ADR actually, not AJS, in the ODPP. And perhaps you would even want to talk about AJS as well. But what are you doing that is linked to this two? And is your work compatible with ADR and AJS?
Thank you, Dr. Sarah. First of all, I like the fact that you've mentioned something about the traditional view of a prosecutor and a prosecutor's work, that your work is strictly to prosecute and to get a conviction. I agree that that is the general perception, but I want to say this here. The work of a prosecutor is to make sure that the ends of justice are served, that you present all the evidence that you have, all the facts that come to your attention that are relevant. As a prosecutor, it is your duty to make sure that those facts are presented before the court. But I want to say this. my work as a prosecutor is not to get a conviction at all costs. What do I mean when I say that? In the course of prosecution, something may happen or an interesting fact may come to my attention that will make me realize that actually the person that I have in court is an innocent person. There are times when that has happened. When you'll have witnesses in court come and testify, you listen to them, but by the time you're getting to PW5 or prosecution witness number 5, you realize that none of these witnesses know the accused person who is on the dock. None of these witnesses, they are all producing documents, but none of these documents relate to the accused person in court. What do you do as a prosecutor? Yes, we love convictions. For a prosecutor, the day I go to court and I get a conviction, that is a good day for me. That's a success story. But as I said, my work is not to get a conviction at all costs. So going back to the question that I've been asked about the reason as to why we are here as a panel, on alternative dispute resolution mechanisms, there are 3 policies that were launched by the DPP towards alternative dispute resolution mechanisms. The first one is a policy on plea bargaining, and I know that was a contentious issue because yesterday someone said there is lack of uniformity. So plea bargaining, what is plea bargaining? Plea bargaining is a negotiation between an accused person or his representative and the prosecutor. What does the accused person offer? The accused person offers to plead guilty to a lesser offense. In exchange of what? Because you see, in an exchange or in a negotiation, I can't give if you're not giving. So normally, the law allows the prosecutor either to reduce the charges. If you are charging him with 5 charges, you can reduce it to 3 or 2 charges. You can reduce the offense if those facts would still lead to another offense, but an offense that is a lesser offense or carries a smaller penalty. The prosecutor is allowed to offer that. Number 3, it's not within the prosecutor's purview to suggest on matters of sentencing. That is something that came out yesterday. The only person who is allowed under our laws to issue a sentence or to deliver a sentence and to decide what the sentence will be the court. But I want to say this. The court will also rely on the sentencing report that is provided by the probation officer. The court will also rely on the suggestion by the prosecutor. The prosecutor is allowed to recommend a sentence. And most of the time when we are negotiating in a plea agreement, we sometimes tell the suspect or the accused who's bargaining, we'll tell them, I will not guarantee you, but I will recommend the court that in this offense, the court should consider giving you a non-custodial sentence, or the court should consider giving you the minimum sentence. So there are many ways of going about it, but as I think the judge or someone mentioned here yesterday, it is a discussion that it's always good to keep the court in the loop, so that even as you continue negotiating, tell the court we are still negotiating, this is what the accused person is offering, and this is what the prosecutor is recommending to the court. And then the other challenge, the biggest challenge that we are having with plea bargains, and I have to say this here, anytime you want to plea bargain as accused person, our condition number 1 as the prosecutor is you must first plead guilty. That one is a must. Yes, you'll plead guilty to lesser offenses. I will promise you that in future we will not bring in more charges. Maybe there was a plan to do that, but you must commit yourself to pleading guilty. Even if we are just going to have you plead guilty to 1 count, that has to be the first step. But you see, sometimes that poses a challenge to defense counsels because they do not want an accused person to have a criminal record. Once you plead guilty, the criminal record will be there. And then as we are negotiating the plea agreement, we'll also advise you that you will have to forfeit some of your rights, the rights to a fair trial. Normally, you have the right to be there to listen to all the witnesses, to bring evidence, to counter what the prosecution is saying. But anytime you decide to get into a plea agreement, the only thing you'll be saying is, I'm pleading guilty, and that takes away your right to to appeal against that conviction. The other ADR mechanism that we have at the ODPP, and this one can come at any time, either before the charges are read out, either before plea is taken, or even in the middle of a trial. We have a policy called a diversion policy. And I'm happy that the previous speakers who made a presentation here talked about it. Under the diversion policy, we say yes, the evidential threshold. For those of us who are here, we talked about an evidential threshold. We say yes, it was met. Yes, the public interest threshold was met. But there are unique circumstances in this case. This is a first offender. This is a very petty offense. It's a misdemeanor. This person is remorseful. How do we handle this? So there will be either a counseling session. We'll recommend any other thing, but just that you don't be charged. We can even recommend that just compensate him if it's an issue of compensation, and then that case will have been dealt at that point. And then you're just given a warning. And then the third policy, in terms of alternative dispute resolution, this one is with respect to corporates. The ones I've talked about are with respect to individuals. There is one called deferred plea agreements. And this one is open to corporates. There's a time when banks were supposed to be charged for various offenses under the Money Laundering Act, which we call the POCAMLA. And they were able to come into an agreement with the office of the DPP. They said, okay, what are your terms? The DPP was able to give them the terms, and then you sign that deferred prosecution agreement, and then you will not be prosecuted for that case. It's a form of diversion, but it's available to the corporate. So yes, we agree that not all cases have to go to court, and actually half of the cases that are reported, or even a lesser percentage, gets to court, because all these cases can be addressed at the various level within the criminal justice system.
Yeah, thank you, Vivian. And Dennis, the name that you do not like being called, you prefer Mr. Mutegi Muthomi. When we heard about NLAS, our picture goes back, our minds go back to NALEP, and our understanding is that you'll give legal aid. Where does ADR come in legal aid?
I think I'll first start saying with the Legal Aid Act 2016 is very clear that it defines ADR to be part of legal aid. And one of the conditions is that whenever you come to office, you must be prepared to submit yourself to an alternative dispute resolution. And failure to either submit, or maybe you may submit, but you are still an impediment, then we also have a right to either to deny your services. So whenever you come to office, depending on the matter, the moment we offer conciliation and mediation. And also, if someone is also willing to negotiate with the office of the DPP, we may advise them on the alternative methods of resolving that case, which, as highlighted, may include plea bargaining and also diversion. So for us, at the forefront, we have to give the alternative dispute resolution an opportunity.
Right, right.
Yeah, a court is the last resort.
Right, thanks.
Yeah.
And Nicholas, what is Huria doing in respect or with respect to ADR? Do you have any initiatives in place?
Thank you. Thank you. Huria is championing the idea of implementation of ADR, or justice restorative system, whereby they go down to the ground, negotiating with people in order to seek alternative justice system as opposed to retributive system in the court system. What I realize as a former convict is that many cases are piled up in court. We have many people in remand for over years on a case that they should have taken a plea the first time, agreed to the charges, be fined and go home. But we find cases where somebody has been fined, has been given a cash bail of 2,500, and he can't raise their money. He has to remain in custody for over a year. Anytime he goes to court, the complainant is not around, he has to be returned back to the prison. Now, what Huria is doing is that when meeting these people, they are us to find an alternative way of resolving these issues. If they can talk to the complainant and agree at a point, then the case is withdrawn from the court, then they find alternative justice. We have cases, notable cases, like in Mombasa prison, that is Kingorani. We have various cases whereby there was a dispute between the two people. One is under remand, and on resolution, the complainants, some of them even didn't want compensation. They only wanted the person to accept kwamba you did this mistake, and the case is withdrawn. So it alleviates that pain, it alleviates the time wasting at the courts, and also the pain of remaining under custody all that year. So as Huria, I'm a beneficiary. On my case, for example, let me use my case study. I was accused of stealing by servant 1.3 million shillings in my former employment. It was a mistake. Actually, it was a policy mistake, but not actual theft. We had 3 accounts. One was an income account, and the other one was payment account. One of the directors instructed me to pay because of the cash crisis. I was instructed to pay from an income account. So it needed a reimbursement of that account for the money that had been spent of 1.3 million shillings. At the point of reimbursing that account, the CEO questioned the reason as to who gave the authority to spend from that main account. So that one brought an issue. I was given a compulsory leave, and on coming back, the charges were preferred against me. So I sought many times to seek alternative justice with them in the initial place, in the initial period, but they refused. So I had to stay in custody all this time. But thanks to Huria, who came at the last minute, and as they were, championing the initiative, many people have benefited out of it. I'm also a beneficiary of the same. And as I'm talking now, I'm championing for the ADR. It is working, it has worked, and it is the way to go in cases where there is no suspicion.
And on that note, where we're saying it is the way to go and there are many benefits, but Daktari, is it amenable for all forms of crimes? Should it be an option for all? What are the limitations, or what are the, the policy considerations?
Okay, thank you, Daktari. Thank you. I think again I will make very general comments because don't have time to go to the nitty-gritties. But I think generally it is accepted that commercial disputes are amenable for resolution through alternative dispute resolution mechanisms. Virtually all commercial disputes, including intellectual property disputes, land disputes, employment disputes, they are amenable. So with ADR, that is possible. With criminal cases, this is where there is some debate. Although personally I've made the point that our Article 159(2)(c) does not limit the applicability of ADR to only commercial disputes. So I think that is very important. Our Constitution 159 doesn't delineate the scope in terms of applicability. And so that even in arbitration, which is historically amenable for the resolution of commercial disputes, you can still use arbitration in certain criminal cases. And this is not far-fetched because you might find an arbitration clause which says that all disputes under this agreement shall be resolved through arbitration. What that means is that even if there are issues of fraud or corruption under that commercial agreement, they are amenable, they are arbitrable under that particular contract. Again, if there are tortious claims under that commercial contract with such an arbitration clause, those tortious claims are also resolvable through arbitration. mediation, again, very common for commercial disputes, actually family disputes, custody disputes, maintenance disputes. We are using it every now and then. The court alternates mediation, the Strathmore dispute resolution mechanisms, the Chartered Institute, the National Center for International Arbitration. All those institutions are using mediation for commercial disputes. But mediation is also amenable, and it's common in criminal cases. And I can say here quite confidently, Section 176 of the Criminal Procedure Code, for example, provides for the use of reconciliation, which by extension you can even say it's mediation. Again, even if you look at other countries, we have seen them deploying mediation. For example, the Kashasha system in Rwanda. You may debate whether it was arbitration or whether it was a mediation, but by the end of the day, there were crimes against humanity, which were resolved using ADR. Again, negotiation, as my colleague from the ODPP has said, they are using negotiation in the plea bargains. So there is no limit in terms of using negotiation in both criminal and civil matters. But there are certain mechanisms that are amenable for certain disputes. For example, statutory adjudication is more common to construction disputes. Conciliation is more amenable for employment disputes and labor disputes. And of course, one of the challenges of ADR, again, I will make a general claim, why it is not generally applicable in criminal cases is because of the general view held that the state is the one that is responsible for protecting the citizens and administering justice in the country. And that's why we have the municipal courts, the judiciary. But of course, you must temper that claim by the fact that all sovereign power emanates from the people. And the people can choose the various mechanisms that they will use for the resolution of their disputes. And of course, lastly, one of the challenge, again, with all these mechanisms is the fact that they also lack the enforcement mechanisms. For example, mediation, you may not be able to enforce some of those determinations. You will need the state to enforce those mechanisms. And of course, in certain cases, such as defilement, you may not want those disputes to go to a few people and deal with them. For AJS, if you look at the alternative justice framework policy, actually it's quite clear because they deploy the agency theory when it comes to jurisdiction. And what they are saying here is that AJS can be used to resolve criminal and civil cases. As long as the parties have agreed and they have subjected themselves to that fora, and there is no public policy rationale for excluding AJS, then they can be used for both types of disputes.
And I like your last statement that where there is no public policy that excludes the use of AJS. And I could see Vivian when I was asking, is it amenable for all? And she was shaking her head. So I presume there is probably some legal limitations or, some of your policy guidelines that may limit.
So plea bargains or plea agreements are provided under Section 137 of the Criminal Procedure Code. And currently we have a policy and we have rules guiding plea agreements. So what we have currently under the system is that sexual offenses and crimes against humanity are not amenable to this kind of an alternative dispute resolution mechanism. So those two have to be excluded. Anytime you have a file and you're considering plea bargaining or trying to negotiate whether parties can agree out of court, you have to be clear that the offenses do not fall under those two. Not sexual offenses, not defilement cases, not incest cases, not rape cases. And you also have to be clear that they don't fall under crimes against humanity. Thank you.
Right, and Nicholas, you talked about good things about ADR. Any downside to it? Any challenges that you faced as Huria?
One of the challenges would be the lack of trust by the complainant on the other side. There are people that they are just made up in their minds they have to punish. In such a case, if you try to look for mediation, they have a fixed mind. Wacha wazee kule ndani. So when you meet such a case, it becomes hard for ADR to work. There are cases where there is lack of proper communication, and especially when, for example, there's a mediator in between the accused and the complainant, and this, the mediator, for example, let me take a case like you're in remand, you are not supposed to negotiate with somebody who is outside. So you'll have to use a mediator. We have had cases where mediators also come in and also, divert the whole picture, and they also make demand on their own. Like we had a case where somebody was charged for 30,000 theft, and the mediation was almost complete, but then this mediator came and said, okay, give me a cut. So instead of this person giving you 30,000, let him give him 50,000, so I also get a cut. So when the accused hears that now I was to pay 30,000, now this one is coming with a 20, he says, no, wacha nifungwe. So that is also another challenge that is coming in. Lack of negotiation skills. There are people who are not good in negotiation. If they are left alone, I've seen cases where even in court, the judge, there's a case to be withdrawn in court, and the judge would give the two time to go and negotiate outside. Give them like 30 minutes, go and agree, and then come back. On coming back, they have not agreed. So whenever there's poor communication or poor negotiation skills regarding that matter, lack of remorse on the other side, it could water down the whole process. So I think when there's lack of trust, lack of proper communication, lack of proper information passing between, it could also water down the whole process.
Challenges, limitations.
I think from my line of work, the most common, since we mostly find ourselves assisting people to come into agreements that have to be complied with monthly, is the lack or the willingness of one party to comply. Because we may agree on this, someone will do it for 2-3 months, then it's another issue. Yeah. And then also some also come with that fixed mindset, and it's a bit difficult for me to convince them that there is that need to perhaps seek the alternative dispute resolution method rather than rushing to court. So I think those are some of the challenges. Also the other one is perhaps the language barrier.
Right.
Yeah.
Right.
It's always an issue. Someone may come is one is good in English or Swahili, then the other one, it's a bit of a challenge.
Yeah.
We also find some challenges when one is a PWD, yeah, particularly to communicate. Right. They may not be able to talk. So that sometimes we may find ourselves having to postpone until we find someone who can translate.
Right. Daktari, limitations?
Yeah, perhaps one of the main limitations that I have seen is the issue of awareness. This is a big challenge. Awareness regarding ADR and alternative justice systems. And if we are to actually have a people-centered justice, we must have a situation whereby the public is aware of what is available outside there. Because if you are to promote negotiation or mediation, parties or Kenyans must know that there is this mechanism where you can access justice more expeditiously. It will foster relationships, it's quicker, and it is more efficient. So we must ensure that that is there. We must also ensure that Kenyans know what are these different multi-doors where we can access justice. So where are these centers? Or if you talk of NCIA, you talk of SDLC, you talk about a center here in Mombasa, the Coastal Mediation Center. Is it there? What are they offering? So Kenyans must be sensitized. When at Strathmore University, about 7 years ago, we worked with the Kenya Bankers Association. We were the mediation center. We realized that the banks, most of them, the ones that referred dispute to the Strathmore Dispute Resolution Center, they became more aware, and their customers also. So, and more disputes came. And after that, KBA was able to roll out their own mediation center. So the public, I think that's where the target, if it is to be the center for resolution of disputes, we must make the public aware. Number two, the advocates. The advocates. I think my own experience, training at the Chartered Institute of Arbitrators, at the NCIA, training judges here, at COMESA, at African Court and elsewhere, the biggest challenge we have to ADR, AJS is us lawyers, because of the thinking, that Eurocentric view of law, of justice. We think that justice can only be served in the formal municipal courts, which is a very, very wrong view. But of course, it has been ingrained in us as lawyers through our legal training. And that's why lawyers say ADR is accelerated decline in revenue, because they see their fees, their money is being taken away. And then number three, also I think awareness. We also need to talk, for example, I think one of the main ways of popularizing ADR is through the media. Through the media. I think if we can have programs where CSOs like Huria partner with the media, so that we even have series, drama series in the media where we highlight, for example, the cases of land, how you can use mediation to resolve a land case, how you can use mediation to resolve children cases, maintenance disputes. I think that's one of the ways of reaching the wananchi in the rural areas and elsewhere in the country. Otherwise, what we are doing when we train, we actually reach out to lawyers who can pay the courses. And that is a challenge. You also need to get to the lawyers. But also, we need to, our training, our universities, learning institutions. The way we train law, we still use that old Anglo-American perspective. You train, taught, you rely on Winfield and Jolowitz, it's contract, you still, and we have compartmentalized the training of law. And not only law, even the other subjects, domains of knowledge. We need to infuse within all these domains of knowledge aspects about access to justice, aspects about alternative dispute resolution mechanisms. Because what is ingrained within the Anglo-American curriculums of law, of biology, etc., is that if there is a dispute, go to court. No wonder someone here this morning said that Kenyans are litigious. Why are they litigious? Because our training is common law oriented. So I see that as a challenge. And of course, capacity building. My colleague has talked about it. There is a gap. I think civil society organizations, Huria included, I think this is a gap that we can fill in so that more Kenyans, more lawyers, more judges are actually familiar about all these ADR mechanisms. And there is a huge opportunity with the AJS. I'm saying this because I've seen it even here at the coast, working with the Mijikenda communities and even negotiating the community development agreements with base titanium. We deployed negotiations in coming up with those agreements. And for lawyers, don't see it as an accelerated decline in revenue. ADR and AJS, there are numerous opportunities so that we don't see only the limitations in it.
Yeah, thank you. One final question to Vivian, and then I'll open up to plenary. In the last session, we were talking about vulnerable groups, and one is children. Is there a specific or special treatment for children with respect to ADR mechanisms by the ODPP?
Thank you, Daktari. With respect to children, especially children in conflict with the law, we give priority to diversion. If there is a way that matter can be diverted from the criminal system. In children's cases, the overriding principle is the interest of the child. It's not in the child's interest to be prosecuted in a matter that would have otherwise been disposed using any other alternative mechanism. Unless it's a very serious case, like a murder case, for us the priority is to divert all children's cases. And there's a children's court with a children's magistrate who was here. We have a special prosecutor who has been trained in handling specifically children's cases, how to handle the children. That court has a very conducive environment for children. It has cartoons on the wall, it has letters, it has diagrams so that when a child wants to communicate about a particular part of the body, they don't tell you do. So there are all these mechanisms to make sure that children who interact with the law have a safe space. And for us, diversion is the best way to go in terms of children who are in conflict with the law. Thank you so much.
Yeah, thank you. May we open up now for plenary? Any questions, comments? There's one here already, this table. And another one here. And Jane there.
I am Omar. My question goes direct to Madam Vivian. But I would want her to make us understand more and more, because in one way or the other, I'm somewhat confused. On the issue of plea bargaining, she talked of 3 things, but I'll talk on these other 2. You said on plea bargaining, one must first plead guilty. And then the other is you'll be forced to forfeit some of your rights. How do we take in this? Because in my view, I feel this is more of infringing the rights of one, because we are told one is innocent till proven guilty. How do we take this?
Thank you. I think there was Jane and there was Tony.
Yeah, I just want to get an opinion from the panel. To what extent should the court entertain ADR, reconciliation in mind, based with the practical case of Mr. Babu Owino versus Felix, the DJ Evolve? Because I know there were some reconciliation efforts made. He promised to buy him an apartment and a specialized car, and I think the charges on attempted murder were withdrawn. Thank you.
Yes, my question goes to Dr. Kariuki Francis. I have 3 questions for you. The first question is, how do you monitor? You see, Article 159.3 of the Constitution on traditional dispute resolution, it provides that it should be used in a way that does not contravene the Bill of Rights, is repugnant to justice and morality, and then is inconsistent with the Constitution or any other written law. So what monitoring and evaluation mechanism have you put in place to make sure, have been put in place to make sure that those determinations emanating from the traditional dispute resolution mechanisms do not contravene the provisions of Article 159C(3). And then also, I know we are heading towards restorative justice as opposed to retributive justice, but you see, retributive justice somehow created a deterrent. So how do you make sure that the determinations being made through alternative justice system is creating a deterrent? Because most of it is just meant to mend relationships and, create the relationship. But how do you work on it to make sure that now you are creating a deterrent so that we don't see ourselves having so many crimes as a result of the leeway that we have given? And then also on the issue of the lawyers and ADR, looking at the ADR bill, don't you think that it was unnecessary for Section 14 to be put in place? And I'll read Section 14 says that a party to a dispute shall take reasonable measures to resolve the dispute through alternative dispute resolution before resorting to judicial processes. It's like you are saying, I think for most lawyers the issue was that it's like you are undermining the judicial process now, and most of the lawyers, as you see, most litigators, that is where they get their bread and butter, and that is why they feel that now with the ADR bill, it's like now you are compelling some of the clientele to resort to ADR first before going through the judicial processes.
Take those in no particular order. Please take it away.
Okay, thank you, Daktari. Thank you. I could start with Jane, because I'll just be giving my views. The ADR bill, of course, I have had also challenges with the bill, because I think some of the provisions, in my view, are not proper. And I think the one you highlighted, clause 14 of the ADR bill, is one such clause. I think just saying that litigants or parties should explore ADR in all cases, that should not be the case. I think it should be in appropriate cases, you know, and the section should define the cases that should be referred to ADR, and the specific mechanisms also ought to be mentioned, so that in cases such as land, environment, and we know these are the majority of cases in our courts, I think that's some of those mechanisms can be referred to ADR as the first port of call. But when you just provide a blanket provision like this, I think you lose the point. And again, the fact that it is coming from law, there is that compulsion which is there. And I see this bill encountering the challenges we see with the court-annexed mediation, where a matter is removed from court, brought to mediation, and then I go there as a mediator. I call the parties to the mediation. One comes, but they say, I have no authority to mediate. You know, and you are left stranded as a mediator. Or you call the parties, they don't come for the mediation. So you can't use the force of law, compulsion, to engender ADR to be used in a country like Kenya. You need to use other mechanisms that will create awareness, so that the people, out of their own free will, because sovereignty reigns, even then, including judicial authority, emanates from the people. But don't use law to force people to actually have their disputes resolved through ADR. And that's why I make the case that the best mediation centers are those ones where you can do walk-in mediations. You just walk in, you get your mediation, but not the ones that are mandated through law. So I agree with you, there is a challenge with that omnibus provision. How do we ensure determination through AJS creates deterrence? I think this is where a lot needs to be done by the state, universities, civil society actors, the media, in terms of removing this thinking, which I say it's a very erroneous thinking, where we think that the aim of the criminal justice system is to punish. I think these are wrong thinking, and that's why I have had problems even with the criminal justice actors, because we think that we must punish somebody, yet we forget that that somebody is someone's husband, is someone's wife, could be the sole breadwinner. He comes from a community. So we forget about our African values. We forget about the Ubuntu. We forget the Utu. But all these has largely been contributed by this legal transplantation of European concepts, you know, which some of them have even departed from them, but we are still beholden to very archaic notions of law. So this is one that I think restoration is far much better. How can we restore these two families? How can we reintegrate this offender in the society so that he can be of more value to the society as opposed to being in prison. If they are in prison, and yesterday we had the statistics, we were told one prison has a capacity which is almost triple. What is that doing to you and me who are paying taxes? I'm the one paying for that guy who is just there, you know? But we can use those resources to contribute towards development. And that's why I agree with all the judges who have decided on a number of criminal cases, including those touching on murder, and they have actually discharged or acquitted them, you know, using AJS, because the essence of justice. And one of the questions I kept asking myself from yesterday, did we define justice? Did we define justice when we started the session? And I think that's a question that we ought to have asked ourselves. Are we seeking retributive justice? Are we seeking restorative justice? Are we seeking economic justice? Because there are also economic issues. So that is my concern there. And then the other one, how do we monitor TDRMs 159.3? I think the AJS framework has tried to provide a framework for monitoring this, part of the deployment of the agency theory of jurisdiction, saying that if there are public policy rationales, like the ones Vivian highlighted, where there is defilement, where there is rape, you know, you need not go to AJS, because there are more important public policy issues that ought to be given prominence to. But there are modes of interaction between AJS and the courts that are provided for also in the AJS framework policy that would temper how AJSs are used. For example, they say that the decision of the AJS decision makers can be taken to court just like arbitration, and the judge can review it and assess on proportionality, you know, and even aspects of due process. What was the due process? Were the rights of the accused followed, the rights of the victims, etc., etc. So I think those modes of interaction that are provided there can help in ensuring that Article 159.3 is attended to. Although it also has a challenge, the repugnancy clause in 159.3, because I hold the view that it will contribute also to undermining alternative justice systems in this country.
Thank you, Dr. I think there was a specific question for Vivian, and then we'll come back to you, Mutegi.
Okay, there was a question on plea bargaining. I think the import of that question was generally what would be the motivation for an accused person to plea bargain if you're forfeiting your rights and if you have to plead guilty. I started by saying that for you to make a plea bargaining offer, or for you to accept a plea bargaining offer, you have to understand that the charges are being reduced. Or if it's one charge, a charge of murder, I don't know, who knows what the penalty is for murder? Are we aware that there are instances where someone has plea bargained, offered to be a state witness, and in such a case, maybe you bear little responsibility and you're ready to testify against the mastermind of that murder case, the one who even hired you to commit that murder as the hitman. The moment you offer the state to plea bargain, to plead guilty to a lesser charge of manslaughter, or it could even be another lesser charge, because really your role was very little. Consider the fact that you're going to be sentenced to 1 or 2 years, or even up to 10 years imprisonment, as opposed to life imprisonment. That is one consideration you have to bear in mind. Number 2, the stigma that comes with being an accused person in court. My friend here has told us he was a remandee. I know he used the word convict, but I'm sure he was a remandee for all that time. You can imagine when you're having a matter pending in court, do you have peace of mind? Does your family have peace of mind? If it's a matter that can be dispensed within 1 day and justice achieved. I know my colleague, Daktari, asked what justice is. But for me as a prosecutor, justice is when the guilty party is convicted and when the innocent party is freed. So being convicted and given a much lesser sentence than what you deserve, for me, that should be enough motivation. Number 2, that stigma
You don't want people in your office to know that you're charged, that you have a mention date, that you have a hearing date. Those are things that. And then there is the financial aspect. Most of these cases, the moment you get charged, you might lose your job, or you might be suspended, or something might happen, and you have to start commuting from your home, and the court is in Mombasa. What is the financial implication of continuing to conduct, and even in terms of judicial time? For me as a prosecutor, I'm happy to conduct, to be engaged in plea agreements, because number one, the caseload becomes very small. We'll not keep talking about the same case after 10 years, after 20 years. So really, the fact that you're being convicted on your own plea of guilty, in other words, you have pleaded guilty to a lesser count, and the court decides to convict you. The moment you're convicted, the law takes away the right for you to bring witnesses. I want you to think about it logically. Why would you bring witnesses when already you've said, I have pleaded guilty? Why would you need to bring witnesses to prove that you're not guilty? Does it make sense? You've pleaded guilty, you've said, yes, I did this, I stole from him, and then you still insist that you want to bring your witnesses to say you didn't steal. It's not logical. So for me, I think it's a win-win situation. There was an issue about uniformity, but currently there is it in the public interest to withdraw that case. So a lot of factors are normally considered by the DPP. This is someone who had been injured, and he sustained severe injuries on his spine, on other parts of his body, and to some extent he's still, he's in bed most of the time. He has a nurse there taking care of him. So the DPP had to balance the interest of the victim. This is a victim whose treatment is being catered by the accused person in that case. And so far, he's committed to providing treatment to his recovery. We could see the medical statements from Nairobi Hospital. We could see evidence of the accommodation, that everything that he promised to do, he actually did it. And there was evidence to that effect, that the house was there, it was already registered in the victim's name, and the promises that were put out there. And that is why I said, in most of these plea bargaining arrangements, you'll find that it's a give and take. What is he giving? What is at stake? So that was a case that was considered on its own merits. And in the circumstances of that case, I believe the DPP made the best decision, considering all the facts that were around that case. I don't know if you're satisfied, the one who asked about plea bargain.
I think it's a conversation that we must go on discussing. I think it's something that requires more time and more forums. I can see one last question. You haven't asked any question throughout the symposium, so we'll allow you, and then as you answer, you will also give your parting shot. Allow Mutsoto to ask the question. I think as the mic comes to him, then Mutegi, you could answer. You had taken the mic. Or has it been said?
I think my colleague, the DPP, answered what I would have said.
Okay, so one final question.
It was a small one. I didn't know you will see my hand, but I just got confused a little bit when you were finishing the explanation on that the Evolve case. Would you say that was plea bargaining or mediation or negotiation? Because the definition of plea bargaining and the ending of that particular case of Evolve, it's kind of brings some confusion. And then just lastly, a small one for Daktari. The challenges that we get, the challenges that are brought about by lawyers in ADR cases, specifically mediation cases, where you have asked for parties to come for mediation, and then one party comes with a lawyer, and that lawyer comes in not to mediate, but comes in as though he's coming into an arbitration case. What would you advise, especially in the presence of Mr. Opulu when he's still here, so that the message you give, the advice you give, he can pass it over to the members of Mombasa LSK. Because many mediations that we have been doing, a party would come in, or, a party would come in with an advocate who would want to, like he's coming to court, and he insists on representing that particular client as opposed to facilitating the discussion. Thank you.
Right, Vivian, and then
I can see that there's another question. What do you want me to?
And I don't want to allow too many questions, because again, we've overshot. It's 4:13. So I'm
intelligent, but he's very ignorant on what a mediation is. And then now I wanted also to ask Dr. Kariuki so that he can comment on it. Earlier on, people had, when the discussion was going on here, and Vivian had also talked about it, that there are some cases in which you cannot apply alternative justice systems, like in children's cases. Sometimes these sexual offenses. I've always held the view that in light of the provisions of Article 159 and Article 51, that position and that provision in the respective acts are unconstitutional. Because if, even international standards, if at all you can have things like what happened in Rwanda, crimes against humanity, being sorted out through the Gashasha system and other alternative dispute resolution mechanisms. If you can have a murder case being resolved by payment of camels or cows, then why do you now discriminate, or why does one piece of law discriminate the sexual offenses and elevate them beyond or make them to be super offenses that cannot be, that Article 159 and Article 51 cannot apply. I think there is a confusion there that the parties here need to be educated on. Thank you.
Yeah. So that I'm not in trouble, I'll allow Mr. Munyithia.
Thank you. I was itching to say something. Now, two things have come out of this discussion regarding mediation. He said that someone asked for a cut. I can say that is a professional mediator. Please, please, if you have to go to a mediation, get a qualified and certified professional mediator and a person of integrity. I'm saying this because I have done mediations, and sometimes, like I said yesterday, a party from Kinango, I did the mediation. We finished a family case where people could not talk for 17 years. At the end of it, I discovered, after writing the agreement, the parties has raised money to give me, and I told them, no, I'm going to be paid by the court. That money is sufficient. Maybe you give the lawyer who had come. And remember, the lawyer who had come to the mediation had already raised a preliminary objection that mediation is a consensual process and the court cannot refer it. So what I did is pass to empower the parties to understand their role in mediation. So what I'll advise Joram, I will not use the words of Opulu, that the advocates are ignorant. I'll do this way. I'll say that first, when the parties come, they sign the undertaking that they are going to stay in the course of that mediation, and that the advocates are going to play the role of a professional. The moment as a mediator you start engaging the advocate that you know, then the advocate will go to the arena of litigation and they will struggle that mediation, it will not move. So the first choice is give the advocate the respect they believe in and tell them by your role is one, in case your parties reach an agreement, you advise them on those rights. But at the same time, you have immunity almost like a judge to be respected for the process and to tell them we stay in the course. When the tension arises, separate them to a caucus. Go and ask the advocate and his client, do you understand what is it that you are doing? I think that's the advice I can give. Thank you very much.
Yeah, and I think that's an important point. So back to you, Vivian, and as you answer the questions, you also give your parting shot, and then we go round the panelists.
The question was with respect to the Paul Ongili case. And the question was whether that was a plea bargain. It was not a plea bargain. It was a withdrawal by the complainant, who is the victim. And that request was not made once. Initially, the DPP was very reluctant, but it became very clear that that was the wish of the complainant, that that case had to be withdrawn for his well-being, for him to concentrate on his recovery journey. And there was a lot of due diligence on the part of the DPP just to establish that there are structures in place that would ensure that even once the case is withdrawn, the measures that are there to make sure that he's being treated, he's being handled professionally, he has a 24/7 medical personnel on call in his house, that everything that was in the agreement was in place. That had to be done by DPP, and by the time the DPP agreed to that withdrawal, that had been done. So yes, it was not a plea bargaining, it was a withdrawal. But again, we have said that even in serious cases, which are murder cases, we normally plea bargain and there are such agreements. So that was the court's decision to have that matter withdrawn. But in the circumstances of that particular case, I think that was in order. Parting short is that still I believe ADR is the way to go, and what we are doing, especially the court where I prosecute, in the murder court, in the high court, what we are trying to, the area that we are trying to move into is that plea bargaining should be given the first priority. Anytime someone takes plea, the first question that is asked during the pretrial conference is, are you willing to plea bargain? Have you thought of it? Do you want to consider it before dates for hearing are fixed? That's the way to go.
Yeah, thank you, Nicholas. Parting short.
Thank you. As we are looking at embracing the ADR, one of the things that we should also look at is the effect that comes with retributive justice. There's a lot of economic loss of time, especially when one is put under custody for quite some time before the case is determined. There is community relation deteriorating. I remember in my case, after 1 year, my children could not remember me. It had to take like 2 weeks for us to bond with the children, for them to know this is daddy again. So that kind of deterioration of relation. So I believe it is important to create a culture where even in dispute, we can create an awareness where we have restorative justice as opposed to punitive justice. Thank you.
Thank you, Nicholas. Mutegi.
I think as a service, we acknowledge the importance of ADR to answer people-centered delivery of justice. And this is shown by the fact that it's only 5% of matters that are handled by local administrators, maybe say from the DCC, the chiefs, that usually make it to the court. The 5% that we are saying is responsible is what is responsible for the backlog. So the question would be, what would happen if you would empower people at the grassroots to own ADR? And towards this, as a service, we are working towards coming up with a manual for training ADR professionals, at least into the perspective of a state-funded legal aid program. And it is with this manual that we intend to train people on the grassroots, people who are in contact with people who may have the disputes, an example being the paralegals, the chiefs, and also other legal aid providers, because we believe through ADR, that would be the first step of ensuring people have access to justice.
Yeah, thank you. Last but not least, Daktari.
Thank you so much. Just to commend Mr. Monyidhia and Okuru, the chair. I think they have mentioned on the question raised by Mheshimiwa here. I think just to add, as a mediator, you also play the role of an educator. And I think the chairman has talked about this. It is your responsibility as a mediator to educate also the parties, especially in cases where you find that there is that gap in terms of the knowledge or ignorance, as the chair has mentioned. But again, in terms of skills and strategy, where do you even position that lawyer? Where do they want to sit? So how you even organize the sitting room as a mediator matters. Ukileta wakili hapa, karibu na wewe, they will think the case is theirs. So you must be strategic. Let them be at the end there and explain. We are putting you there because this is mediation. It's all about the parties, party autonomy. So you don't put them at the end, waone kama unawafukuza. And then, on that still, you also explain to them the role that they play. And I like what Justice has said. They have a role, but keep reminding them that this is mediation. The decision will emanate from the parties themselves. But whenever there is a legal issue that arises, we will come to you. Whenever there is an issue of drafting the contract, we will come to you. So don't send them away. They will frustrate you. That mediation will never come to a mediation settlement. And I agree with the chairman. Cases where AJS cannot apply, like sexual offenses, I think this is a lacuna. This is a problem of Kenya. We make laws without being informed by evidence. We make laws without being informed by empirical research. What is the basis of saying you can't use AJS in sexual offenses? There is none. That's why we make constitutions that are not applicable. They are not fit for purpose. It's okay. It's a good paper. It's the most transformative in the world, but it doesn't speak. It's not in line with our economic status. So I agree with you, Chair. And the other laws can be challenged as being unconstitutional. 159(2)(c) does not limit the scope of application of ADR or TDRMs. And then, just as a way of closing, I'll just say three things. Number one, I think as we seek to reimagine or rethink the justice system in Kenya, I think we have to look for mechanisms such as ADR, AJS, that are culturally acceptable, that are culturally familiar to our people. Let us not have all these court buildings, and I'm an advocate of the High Court. Let us not have courts even in villages that are not serving the people. That is not people-centered justice. We'll just be wasting money, but justice is not being served. Our former Chief Justices have said 95% of cases are resolved out there, not in courts. Number two, we need to do a lot of research on customary laws, customary practices of our people, and study how can they inform and underpin the formal justice system. Number three, I think we need a serious intercultural engagement, intercultural dialogue. There is no justice system that is superior to the other. You can't say the Anglo-American is superior to Kenyans. Thank you.
So thank you very much, panelists, for that very informative and insightful session. We have learned a lot. I'm sure you have really appreciated that session. What happens with new ideas, it's sometimes we engage with them without even understanding the core tenets of the ideas. So it was refreshing just to hear you talk about the major components of AJS and ADR, and thank you very much. Another session begins, a very short session, and a round of applause as they go to sit. Thank you very much. I had promised a very special group of participants represented by Mama there, because we cut them short in the last session, and she agreed just to say a word that is directed to Honorable Adr. Karibu. Mama. Remember, we are talking about people-centered justice, and they told me, you have not allowed us to say even a word, and we are representing a constituency. So just allow her 5 minutes. I seek your indulgence. She had a specific word on SGBV. Karibu sana.
Kwa majina naitwa Helen Maere. Mimi ni mama mtaa, village elder from Shanzu. Kesi za watoto ni nyingi, na sisi village elder tunazijua, na kufatana na kuwa familia ni maskini, watu wakienda pale Bamburi inaisha hivyo hivyo. Unakuta mtoto wa miaka 8 amefanyiziwa, ametumika vibaya mbele na nyuma, amepelekwa Bamburi, mimi nimebeba huo mzigo nimepeleka kule. Hiyo kesi imenyamaza. Ukiangalia mzee wa mtaa amejitolea mpeleka pake mtoto Bamburi. Mzazi wake umemchukua mara ya kwanza umebeba na tikiti. Jambo la kwanza wazee wa mtaa mwajua walipwi. Niwe nikufanyie kazi uone haya utoe shilingi 100 unipe. Kwa hivyo ni pesa yangu mfukoni nichukue huyo mtoto amefanyiziwa wa miaka 8 na mamake nipeleke Bamburi. Hiyo kesi chifu anasema imepita uwezo wake. Tukipata hizo kesi sisi kama wazee wa mtaa tunapelekaga Bamburi. Nafikiri wa mama wote Shanzu wananijua. Tumepeleka hiyo kesi, mwisho wa kuisha mama anasema mimi sina tikiti, amebaki kujaza P3. Huyo mtoto yuko hapo nyumbani. Kuna kesi nyingine, baba alifutumia mtoto wa miaka 7. Baba sijui alitoka na bond, rumu ni moja, amerudi ameishi tena na yule mtoto pale pale ndani. Lakini kwa vile sisi ni kitengo cha chini kama wazee wa mtaani, watu wa chini kabisa katika community, kwani sisi tu huwa tunatoa habari lakini huwa hatuthamini. Unaenda unasema hakuna hatua yoyote inachukuliwa. Sasa mimi nilikuwa nasema hichi kitengo nasema cha jaribu kutetea watoto, wachukua information kutoka kwa wazee wa mitaa, lakini watoto wengi wanateseka ndani ya hizi jamii zetu. Na ukifuata sana utaitwa mbaya, waambiwa wewe basi kama unaona iwateseka si umchukue kampeleke skuli. Mama ni mlevi anatesa watoto. Kuna mama mwingine nilifuatizia alifungwa miezi yake 6 na akatoka. Watoto wanasomeshwa hapa Pundamilia na masista. Sasa tuseme ikiwa kuna kitengo cha kutetea watoto kama pale, naona kuna wengine anasema sisi ni watu wa watoto, lakini huku mitaani hatupati usaidizi vile. Na hata ukifuata mtu anakuambia mimi sina tikiti hata ya kwenda town. Hao watu mnawafikiria mtawasaidia vipi watoto wa aina hiyo? Maana watoto wa hivyo ni wengi, na wazee wa mitaa kila mtu kimwambia lete wako wawili ataleta. Lakini sasa pia mtu anaogopa. Sengine hapa kuna wazee wenzangu naambia tuzungumze, wengine wakwambia sitaki maneno. Ukifika kule utaulizwa, maana si wa mtaa pia tuna wakubwa zetu. Ulienda kusema nini kwa ule mkutano? Sasa unakuta tuko wengi lakini hakuna mtu yotaka kusemea issue ya watoto, lakini watoto wako mitaani ambao wanateseka na wanadhulumiwa na watu wazima, haswa wazazi wao. Lakini mzee wa mtaa atafanya nini? Utajua na utamezea, maana kuna kitu utafanya. Utapeleka Bamburi, mama kama ataitwa, kijana akitoa kama shilingi 3,000, mama akipatiwa amezima. Wewe mzee wa mtaa ukifika, mwanzo hata wa kukimbia. Mama mimi ninamsamee. Unamsamee na huyu mtoto ni wa miaka 8 akiwa mkubwa atafikiria vipi? Sasa sisi wazee wa mtaa twatumika, lakini hatuna mtu wa kutupushi wa kutusaidia kusudi hao watoto wapate haki yao. Sasa nilikuwa nasema haya mashirika yashirikiane na sisi, hata kama hatulipwi sisi tumejitolea tupate kontakti zenyu. Tukiona mama amekataa kuwajibika kuhusu watoto, tayari na kupigia simu tusaidiane. Lakini mkisema huku kwa jamii ati community itasaidia kufanya mtoto apate haki, atapata vipi? Na wale wako juu hawafiki huku chini. Mpaka mfike kwa sisi wazee wa mtaa ndio mpate full information. Mkibakia kule juu, chifu azunguki kwa mtaa, ndio azunguki kwa mtaa. Mimi ndio nazunguka kwa mtaa wangu. Mimi ndio naweza kuambia watoto wangapi hawasomi. Mimi naweza kuambia watoto wangapi wamedhulumika. Sasa pake mtutumie sisi, nyinyi mnaodili na watoto kuwasaidia. Kuna watoto hata ukimwambia unapeleka orphanage atashukuru, maana ile maisha anaishi kwao haistahili, na mzazi yuko lakini labda ni mlevi, mtoto hasomi. Sasa vitu vingi ambavyo vinafanyika huku chini, jaribuni kushika wazee wa mtaa mpate information. Msikae maofisini mkisema nyinyi kitengo cha watoto na huku mashinani hamfiki. Sasa nimesema hivyo, najua nitakwaza wengi lakini nimesema.
Asante sana kwa kuzungumza. Nadhani jambo la kwanza kabla Honorable Adr azungumze ni kwamba kuna kitengo cha Child Protection Unit ambacho Inspector Millicent na wengine wanaendeleza haki za watoto, na jambo muhimu ambalo wanafanya ni wanapoambiwa kuhusu hizo kesi ambazo haziendelei, wanakuja na wanazungumza na nyinyi na wanawaelekeza jinsi ya kuendelea. Kwa hivyo pamoja na Huria tutafanya mikakati muweze kujua hao wa Child Protection Unit, mpate namba zao ili muweze kuwazungumzia kuhusu hizo kesi. Lakini Honorable Yator, sijui kama kuna lolote ungetaka kusema.
Shukran. Yale umesema yanasikitisha sana, na kutokana na vile umeongea ni kama kuna changamoto pia police station, ambapo ni kama mkiripoti.
Mama Elena una kazi ya kufanya. Tena naambiwa na polisi ambaye yuko kwenye jenda. Wewe Mama Elena una kazi, kila saa unaleta wasichana wanshikwa. Huyo alikuwa anshikwa na babake na yuko form 2. Baba akamwambia school fees. Na msichana class 8 alipata 480. Ameacha skuli. Yuashishi kwa watu tu, ni msichana. Ana 16. 16 si msichana mdogo. Huyo madam ananiambia huyo ashakuwa, ashajua kila kitu. Tafuta kazi ufanye Mama Elena, achana na watoto kama hawa. Mamake huyo bwana amemshika huyo mtoto, mamake yuko naye. Sasa mama yuasema sasa huyo bwana niko naye, nitamshtaki vipi? Hapo mzee wa mtaa wajua utafanyaje? Na neno lishafika polisi. Chifu ukimuuliza yakwambia si ushafikisha polisi Mama Elena? Hiyo kazi ni ya polisi, lakini hakuna kitu kinaendelea. Tutasaidiana vipi hao watoto tuwasaidie?
Kweli yasikitisha, lakini maybe upande wa DPP kama nimekosea mtanirekebisha. Nafikiria kama mtu ameripoti kesi na ikose kufuatiliwa, nafikiri kuna ofisi ya DPP wanaweza kupata usaidizi huko wa ripoti kwa nini hiyo kesi haifuatiliziwe. Na pia kuna IPOA nafikiri inasaidia pia, lakini ile mimi naweza sema tu na tutakupatia tu. Kabisa.
Najua nitaenda sema huko lakini potelea mbali. Kwa sababu wengi.
So kwa hivyo kuna organizations nyingi zinasaidia, na nikianzia nikisapotiwa hapa na wakili wa FIDA, kuna toll free number, kuna namba ambayo unaweza piga ambayo haulipishwi chochote ukipiga. Na kama unaweza chukua hiyo namba, ndio hii hapa, ni 0800 720 501 0800720501. Pia kama kuna swala la mtoto, kuna pia ile namba ya 116, ama I hope sijakosea 116 Pia hiyo namba unaweza piga na mtoto akapata usaidizi. Na pia unaweza piga koti, sisi pia tunaweza saidia kwa kukulink na ofisi ya CPU. Namba ya koti tutakupatia, na ni public number, si ati tunaficha. Wacha nikusomee ya koti ya Tononoko, pia utapata usaidizi kutoka huko. Na namba ya koti ni 020 259 3640. Kama kuna changamoto unaweza tupigia, na sisi tunaweza kukuhook up na kukulink na wale wanaweza tusaidia kama FIDA, kama Child Protection Unit. Nafikiri wako hapa leo, pia watashare namba zao ndio ili tuweze kusaidia watoto wetu. Kuna watu wengi wanaweza saidia. Ukifukuzwa unafaa kutuambia, hata sisi wenyewe tunaweza piga simu tuulize kwa nini hiyo kesi haifuatiliziwi.
Labda pia kusaidia Honorable Yator kujibu hilo swali, Madam Chief, ni kwamba wakati tulikuwa tunaongea pale nilisema kwamba tuko na sheria nzuri sana ambazo tumeziweka, lakini kuzi-implement ndio imekuwa ni shida. Kama hiyo swala ambayo uko nayo ya mtoto ambaye analawitiwa na mzazi wake, na kila wakati ukiripoti anasema amekuwa mtoto mkubwa, achana na hiyo mambo. Na ni si mara moja, si mara mbili. So kile ambacho tulikuwa tunasema ni kwamba katika the Children's Act kuna orders ambazo unaweza apply kotini, na vile Yaratora alisema kotini si lazima uweke a formal application. Hata wewe mwenyewe unaweza enda pale ukaongea ukasema kwamba mimi nataka hii order under the Children's Act section 114 order ya exclusion i-apply kwa huyu mtu kwa sababu ya ABCD. So instead of kuchukua mtoto kumpeleka kwa rescue center, unaweza apply yule bwana ndio sasa atolewe pale apelekwe kwingine.
Ule bwana ni mwalimu.
Ndio nimesema sheria haibagui.
Ni mtu ni msomi na akili zake yofanya kitu akijua.
Sheria haibagui.
Mimi mwenyewe shonipigia simu akaniambia mama Elena wateseka utanifanya lolote. Na yuko.
Ndio nimesema
sheria. Kuna watoto wawili walicomplain, wazazi wao wakaambiwa waende wakaripoti, wakasema sasa ni mwalimu wa watoto wangu atafundishwa na nani? Walikuwa ni Waswahili wetu.
Sheria haibagui. Children's Act ime make that provision that unaweza tumia hiyo order ukipeleka kotini, koti inaweza peana hiyo order na wakaona mahali huyo mtu atapelekwa mbali na hawa watoto.
Kuna mkono pale nyuma.
Asante. Pia ningeongezea kwamba kila sub-county tuko na ofisi ya watoto, na vile nimesikia unazungumza mambo ya Baburi, basi inaonekana ya kwamba hiyo ni sub-county ya Kisauni, na Kisauni kuna ofisa ya watoto. Ningeshauri ukiripoti kesi kwa polisi, pia unaripoti kwa ofisi ya watoto ndiposa waweze kufuatilia. Na pia ningekupea nambari ya ofisa ya watoto wa Kisauni, unaweza chukua. Ni vizuri ukiripoti kwa polisi, pia unaripoti kwa ofisi ya watoto Kisauni ndio wafuatilie. Sawa eh?
Is it in response? Sawa. Tukifunga.
Will you allow me to speak in Kiswahili? Amjambo tena. Mimi kwa majina naitwa Godfrey Masamba na natoka shirika ya Beko, organization ambayo inajisaidia yenyewe. I am based at Bamburi, na ningeomba kuambia madam, labda ajui sheria inasema nini. Kuna mambo mawili matatu amezungumza hapa, nimemuunga mkono, lakini kuna mengine siwezi muunga mkono, kwa sababu mimi nimedili na mambo ya watoto Bamburi location tangu 2002, na hakuna kesi imepitia kwa ofisi ya Beko bila kwenda kotini. Na ikiwa mtu ameshikwa, ameenda kotini, amelipa bond na ameachiliwa, nina haki kweli ya kufuatilia kama ofisa wa watoto? Si hiyo imenipita? Kwa hivyo madam asiseme kwamba kuna watu wengine hapa watasema nimefanya hiyo kazi. Mr. Evans anajua I'm not being paid. I pay myself, I do my work, I have my office. Lakini shida tulionayo saa hii, ile naweza sema, ukienda Makadara saa hii na mtoto under age, unafukuzwa, unaambiwa nenda uite mama yake. Mtoto ameolewa na miaka 16 form 1. Nimerescue ile mtoto kupeleka kwa jenda apate haki. Niliambiwa hii barua pelekea mama yake, na mama yake ashachukua mahari. Wakati mwingine pia mtusaidie bwana. Mimi silipu na mtu, lakini nimejitolea, nikipachi mtumwa na Mungu. Nina ofisi yangu hapa, secretary mama. Kuna kesi imekuja ikatushinda. Mtu asiamke kusema kwamba watu wengine wameshindwa kesi. Hatujashindwa kesi. Na hata Bamburi police, okay, labda wanafukuza mama kwa sababu wanaona ni mama. Lakini kwangu mimi ni mwanaume, siwezi fukuzwa, najua haki. Na nimekuwa kwa system for 20 years. 2002 mpaka leo, si miaka mingi. Na ninaomba pia wazee wa mitaa, mtajitetea mkisema kwamba wameshindwa. Lakini nyinyi nani mnafanya kesi mkila mlungula? Ndio mnatushinda. Ama niseme nisiseme? Je, juzi kesi imefanywa, mtoto ameonyeshwa mdudu, mtoto wa miaka 8. Ninasikia ilipitia kwa wazee wa mitaa na mwenyewe akalipwa 15,000. Hiyo ni haki kwa mtoto? Na ingefika kwangu huyo mtu angepitia kotini. Walai, huwa sina mchezo. Yaani mimi ni mbaya tu kama vile sura yangu ukicheza na mtoto. Tunaelewana? Kile tunaomba, huyu mama anafanya kazi sana, lakini amedharaulika. Wanaona ni mwanamke tu. Anafanya kazi vile mmesikia anasema anabeba watu anapeleka huko. Mwanamke mwenzangu ofisa na muangalia, naona huyu mama anajisumbua. Hapana, anataka haki ya watoto. Kwa hivyo ombi langu, kama tunaweza shirikiana, na pia mimi mnitambue kwamba nina ofisi ambayo hatulipi na tunafanya kazi ya watoto. Katika faili yangu nina kesi zaidi ya 30 ambayo watu wamefungwa miaka 10 na. Si ati nasema urongo. Si ati nasema kwa sababu leo nimeingia Pride. Naomba mnielewe. Tushirikiane. Watu wa hospitali sasa wamenikeuka, mtoto ameolewa, nataka kutafuta haki, ninaambiwa naenda hii barua peleka polisi, na uambie mama yake mwenyewe apeleke hii barua polisi waje washike ile mzee. Sio kijana, huyo msichana alienda tena kwa bwana. Kama mimi ningefanya nini? Na nishafanya kazi yangu. Kwa hivyo maombi yangu, ninaomba mjue kwamba Bamburi location kuna ofisi inaitwa BECO, Bamburi Education Enforcers Committee. Imeanza 2002 and I'm the chairman. I have never retreated since I started. And I'm there to help children. Hata wamama wakipata shida mimi wasaidia. Si ni kweli? Unacheka. Ngoja upigwe alafu uje kwangu nitakusaidia. Hayo tu ndio maombi yangu. Na ningeomba pia mashirika nasikia nasaidia watu. Tafadhali simkuje kwa rescue kwa timu yangu. Hatuna rescue center Bamburi location. Na hakuna vile tutasaidia watoto bila rescue center. Mtoto amepagwa na baba yake na anarudi kulala na baba yake. Kama serikali tunafanya nini? Kama serikali tunasaidia watoto vipi? Au tutakuwa tukikaa mikutano tu kila siku tukisema tunasaidia watoto, tukila buffet, tukipewa allowance na watoto wanaumia? Tunawasaidia vipi? Ninaongea kwa sababu wakubwa wote wako kwa hii nyumba. Sijui kama mnanisikiza.
Tumesikia.
Yes. Kwa hivyo mimi naomba tu hayo maombi. Na nitawatafuta, mkinipa namba, mimi ni mtu wa kuomba. Nitakuja kuomba na usinifukuze.
Karibu, namba utapewa wakati tume break for tea.
Nina lawyer wangu hapa.
Sawa.
Atanisaidia.
Okay.
Asanteni sana. Lakini nataka niambie mama mtaa, kuna msichana amesema alipakwa na baba yake. Nilifuatilia hiyo kesi, ile mtoto ni mkora.
Okay.
Sawa.
Shukran sana.
Mtoto mkora.
We can just point out. So thank you very much. Allow me now to hand over to Winnie.
Thank you. Tujipigie makofi tena. Thank you Dr. Sarah. and the panelists wale ambao wametoka hapa. I think we've had very great deliberations, rich discussions for the 2 days that we've been here. And I want us to recognize one person ambaye amefanya kazi nzuri. Sote tumefanya kazi nzuri, lakini yeye amejibidisha kwa zaidi sana. Na ningependa tumshukuru kwa makofi, shangwe na nderemo. Catherine, our sign language interpreter, kindly stand up. Stand up. Kindly, makofi endelee. Let's appreciate Catherine. Inapigwa hivi ingine inapigwa. Thank you, Catherine. You've done a wonderful job. Thank you very much. Yeah. So as we move to the last session, I would like to invite a few individuals who will make closing remarks. Kindly take very few minutes, and then we'll have another session ya meet and greet out there. Yale maswali ambayo tumekuwa nayo hajajibiwa, you'll get an opportunity to interact further during tea. And I hope we've exchanged contacts, networks to create in this colloquium. So first I want to invite Dr. Kariuki Francis. Is he in? Dr. Kariuki? Oh, okay. Karibu Daktari, Huria's Associate Director. Karibu.
Thank you so much, Madam Moderator. I think mine at this juncture is first of all to appreciate Huria in a very special way as it celebrates its 10th anniversary. You recall yesterday when our executive director spoke, he said this is a field that is highly competitive. So I think mine is to urge all of us to give Huria, as it celebrates the 10th anniversary, a loud applause. And of course, this could not have been possible without very key people within Huria, especially the executive director and his team, the head of programs, and all the other members within the secretariat. So wherever you are, please feel appreciated for bringing Huria this far. And also, I must also appreciate all of us who have especially been here with us for these 2 days as Huria. Some of you for Huria as we turn 10, happy 10th birthday. Thank you, sir.
Thank you, thank you. Thank you, Daktari. And this colloquium will not, have been convened the way it has been convened if it were not for the partnership that we have created with the University of Nairobi. And I would like to invite Dr. Sarah to give her closing remarks.
Good evening, everyone. My name is Anthony Amboy. I'm a student at the University of Nairobi studying law. And most students, when they attend the law school, the first years would ask them, why do you do law? They say, I want to change the community. I want to help out in the world. And a partnership like this, where we come here, we listen to actual ways which we can change and affect the community, is very helpful for us. So it was very enlightening for us, and we look forward to pass on the knowledge we've gathered here today to our fellow colleagues at school. So thank you very much.
All protocols observed. Good evening. First of all, I'd like to start by saying a big thank you to all of the stakeholders who have been integral in making this colloquium a success. We would not be here if it were not for you. As you've all heard, this is the very first time we're having this in Mombasa. So hopefully, as we've been here for the 2 days, for the stakeholders, you have heard the concerns of the people, you have seen where the gap is. So let this not be the end of the conversation. Let us go forth and work on bridging that gap. So thank you very much. And to the members of the community, asanteni sana kwa kufika. Tunawashukuru, maoni yenu na maswali yenu ni ya muhimu sana. And as we go forward, tunaomba kuwa mtashirikiana na all of the stakeholders that have been here, ili tukaweze kuleta justice kwa mashinani, ili complaints zote ambazo tumezisikia siku ya leo zikaweze kuwa addressed. Sawa sawa. As we leave, I wish you all a good evening na safari njema mnaporudi nyumbani.
Thank you. Thank you, Pendo, from your end. I would like to invite Zainab, Madam Zainab Ali from UNDP. We really appreciate the support that UNDP has given to Huria for the last 3 years now. So they are part of the success, they are part of the decade that Huria is celebrating. Thank you, Zainab.
Thank you very, very much. I think for me, I just want to start by thanking Huria for organizing this colloquium. You have given each and every one of us an opportunity to engage. I remember, and I think in your concept note, you indicated the importance of identifying the barriers that are there within access to justice and how those can be addressed. Nyote mlioko hapa, mumemsikia Mama Elena. If it was not for this particular forum, labda hatungejua ni shida gani anazipata. Kwa hivyo already imetupatia changamoto ya kuona ni namna gani tunaweza kusaidiana. That is one. Jambo lingine, inaonesha umuhimu wa kila mmoja aliyoko hapa, kwa sababu kila mmoja ana kazi ambayo anaweza kuifanya akamsaidia mwingine. The justice actors wako hapa, civil society iko hapa. Swala ni tufanye vipi kuleta watu hawa pamoja, ili watu wetu walio mashinani ambao hawana uwezo wa njia yoyote. We are talking of the, I was told by my colleague, sometimes we tusitumie the word poor, but liko, the poor and the marginalized. How do we help them? In our discussions also, it came out very clear that civil society is a bridge between them and the duty bearers, as far as the communities are concerned. Kwa hivyo, tukifanya kazi zetu, let's also bear that in mind. Also la muhimu, tujiulize, ni best practices gani tunaweza kutumia ili tuweze kupata lengo letu la kuhudumia access to justice. Tuanzie na alivyosema Mama Elena na shida na changamoto anazozipata. Tujiulize sasa sisi, ni mikakati gani tunaweza kuweka ili tuweze kuwafikia watu kama kina Mama Elena na wengine wenye shida ambazo tunataka kuzitatua. Tuangalia upande wa technology ambaye ni muhimu pia, inatusukumia kazi, inatufanyia kazi wepesi. Angalieni, when we started the workshop na changamoto tulikuwa nazo na technology, lakini tulikuwa na wakubwa ambao hawakuweza kuwa hapa physically, lakini wametujoin through the Zoom links na tumeweza kuwasiliana na wao. Kwa hivyo tujaribu kuangalia ni vitu gani ambavyo tunaweza kutumia ya kuweza kusongesha mbele nini huu mjadala wa access to justice. Ya mwisho ni kuambia kuwa kama UNDP, na tumefanya kazi na nyinyi Plead, Huria katika hii nini ya Plead kwa kiasi ya miaka 3, because the program is almost 4 years now. Tunamaliza around July Plead phase 1. We are hoping that tutapata opportunity ya kuendelea na Plead phase 2, lakini pia tujiulize ni results gani ambazo zimetoka ambazo tunaweza kuzitumia kuendeleza ikiwa tutapata opportunity ya Plead 2. Kwa hivyo la mwisho kabisa ni kuhakikishia support yetu kwa njia ambayo yote tunayoweza. Tuna build capacities za CSOs so waweze kuengage na duty bearers. Tuna build capacities, tumewafanyia mengi kuhusu organization zenu Bwana Musoso na nyote, na mnajua tuko tayari kuendelea kuwasaidia. Kwa hivyo kila mmoja ajiulize ni role gani ataweza kuendelesha ili mambo yafanya. Na kazi hiyo ifanyeni kwa nia ya kusaidia wale ambao hawajiwezi. Sitaongezea kwa sababu mengi yamezungumzwa. Na nina hakika katika action points zote ambazo zimetoka katika mkutano huu zitaweza kuendelezwa through Huria na wengine wote ambao wana role ya kuplay. Kwa hivyo ya mwisho kabisa ni kuwashukuru nyote. Huria, asante sana 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 kwa kutuleta hapa, kwa kutupatia nafasi hii, na tuna hakika ni mjadala na ni mazungumzo ambayo yataendelea. Na mwisho pia ni washukuru nyote mlioko hapa na kutumia wakati wenu, partners wote walioko hapa, justice actors wote walioko hapa. Letu ni tuko pamoja. Tuko pamoja. Asanteni sana na nawatakia kila la kheri. Thank you very much.
Thank you. Shukran sana, Madam Zena, and thank you to the UNDP team. Thank you for working with us, for supporting us, supporting our work on access to justice, and placing us to where we are as an organization. So at this moment, makofi naona anaenda akipungua nguvu. Ningeomba aanze kuzidi kuongezeka, tukipiga makofi tupige kwa nguvu, sawa sawa. So I would like to invite the Principal Magistrate, Honorable Adr, to give her closing remarks, and then we'll later on invite Justice Munyidhia atufungie officially. Karibu.
Good evening. Okay, on behalf of Tononoka Court, Tononoka CUC, and the judicial officers who are here yesterday, I'm told, or even today morning, we are so grateful to be part of this team. Surprisingly, Huria is one of our CUC partners, Tononoka CUC, and including all those people you are seeing, MLS, UNDP, I think those ones, yeah, UNDP, and yeah. So mine is just to thank you for partnering with us and calling us for this colloquium, because it goes hand in hand with our judiciary transformation pillar. I think it's pillar number 1, access to justice. Thank you so much, and we wish you a happy 10th anniversary, Huria.
We'll be sending the photos for the 2 days that we've had here via email. I think a link has been created. So we'll send the photos to you. You select your photos, kindly post Twitter, Facebook, continue, including the hashtag People Centered Justice. If you're not on Facebook, join Facebook, like Huria's page, share the photos and retweet, okay? So at this moment, to officially close the Access to Justice colloquium, I would like to invite Mr. Justice Munyidhia, representing Huria Board of Directors. Makofi, makofi.
Thank you very much. Asante sana kwa wale wamezungumza na wale wameongea mbele yangu, nasema asante. Just look at left or right. Do you have a partner sitting next to you? Uko karibu na mtu ambaye ameketi karibu na yeye. Mtazame, muangalie kwa macho, mwambie it was worth it. Sema tena. Was it worth it? On behalf of Huria, I would like to take this opportunity to thank each and every one of you who sacrificed to be with us these 2 days, and more so those of us even sacrificed the hour to go and pray, being on a Friday, to sit in here. those of us who traveled, left their businesses so that they can spend time here. I will start by appreciating the end of the judiciary in Mombasa, Justice Mativo, who was here with us from 10 o'clock to the end of the day. We had Honorable Mutuku, I think she was here again with us. And today we're happy to have been joined by Yator. I've only heard about you, madam, and thank you for coming. Just to remind you that Tononoka Court was actually a collaboration and a product of MLS, and people will confirm, Action in Kenya, and yours truly. I was a children lawyer for many years in this. I'm proud. When I came, I saw the containers, I saw the swings, and I said the dream has been brought to fruition. So that tells us testimony about the organization that came. It's about commitment, it's not competition, it's about collaboration, so that all of us can deliver access to justice for those in need. I also want to appreciate the Deputy Director, ODPP. She was with us, deputizing Hassan Abdi, who could not come. Madam, thank you very much. We had the Deputy Officer in charge, Remand Prisons, was here. We had somebody from CAJ, Coordinator for Ombudsman. We had Brenda from National Human Rights Commission, and all the plead partners. And I like this collaboration where all of us come together to achieve. I was touched by what I've heard about Lamu, in Peketoni, and all those centers, what they are doing for the benefit of the people in this region. Indeed, the discussions were about the cost access to people's center justice. I will not have done justice if I didn't mention FIDA. Jen, you followed us yesterday, and we got your question line, and today you came here together with all other civil society organizations, including Kitruo Church area, where I chair the board, and our partners plead. Uria for leading in the front, University of Nairobi for being a source of knowledge. Just to disclose my interest, I'm an alumni of University of Nairobi, and we were championing to see a branch of University of Nairobi in Mombasa. We hope it will grow to be the Mombasa University instead of being a branch. I'm sure members of the counties in this region will appreciate that. And Dr. Sarah, thank you so much for giving the students what I call a clinical approach to dispute resolution. When I was young, I remember these opportunities were very rare. I don't think Professor Ngethu would carry me to a conference, but I do remember once in a while we'll be invited as student leaders to sit at the back. But this time I've seen students leading from the front to ensure that they are part of this collaboration. Zainamu, we could not have worked without you, and without having you sitting at the right place and making decisions that impact to bring to give resources that have been able to support us. We are grateful to UNDP for what they have done. But I'm told that in every step that people take and in every journey, there is always that young man or young woman who becomes the spanner boy, who is always given the tools to conceptualize and come up with something that will deliver. And I would like us to give special mention to Tony Magaga. I don't know whether, Tony, you are my student. Tony, can you stand up? Let's appreciate Tony Magaga for putting this together from Uria and trying to ensure that everybody was here on the ground. I remember when I almost missed my flight and SGRI is gone, I didn't know what to do. I caught Yusuf very late. I told Yusuf, can I join online? But he told me I must be here physically. And with that, I appreciate for giving me that opportunity. We had a team dealing with ICT. I could hear prayers, there was music, and they brought us great men and women to speak to us right here. And I appreciate you so much for what you did. Those efforts are not in vain. But I'm told that over and everything else, there is always a captain of the industry who leads not only from the front, but also from the back. Yusuf Ule, the only Yusuf we know. Thank you so much, Yusuf. Maybe we could allow Team Uria to stand up, because although we are board members, but we have the people who sit on the ground. Where is your team? Just to appreciate the team. Yusuf, yes? You've just heard about Uria. Yes, let's give them a club. Yes, please. Tuwapatie makofi tena. Thank you so much and congratulations for walking the 10 years journey. Asante sana. Proudly associated. I remember when I had been called for an interview to be the chairman of National Commission for Human Rights, Uria sent a very serious memorandum. And the board had no alternative but to say this is a good man. But they needed one person who needed to be a woman. So my colleague whom we worked with happened to be a lady and she was taken. But we are together. I never got it, but I'm leading from the front in terms of human rights realization. Now, my closing remarks, which is very important for us, as I appreciate all those who have come, is that today marks a very important milestone for Huria. Having walked the journey for 10 years, as a vibrant civil society in the Coast region has been able to come up with the programs that other organizations can come and benchmark. This colloquium on access to people-centered justice has marked the milestone that they have done by bringing together partners, that is state and non-state actors in the first colloquium in the Coast region. It demonstrates the strengths of when people cooperate and coordinate affairs together and when people are not competitors. I still remember Yusuf as a young man when he was working with Buhuri. And from that, we have seen what he can do as a CEO of this organization. We have seen that we can come up with homegrown solutions, both on access to justice and other areas, especially on dispute resolution. The Legal Aid Center, the Legal Aid Clinics with collaboration with the University of Nairobi, the community centers set up in Lamu through PRID, and also the collaboration with the judiciary and the county of Mombasa will yield results for the benefits of the people of this region. We have rights in the Constitution. We have both socio-economic rights, which are installed. We have a key Bill of Rights in our Constitution. But unless our communities are empowered, unless our communities are educated, you realize that this will not come. In this forum, we brought lawyers together. Mombasa Law Society was present, led by the chairman. We had the judiciary led by the resident judge. This is a demonstration of how organizations are working together. We hope that what we have discussed today, and I hope there was a rapporteur, can be turned into a journal so that we can read the minds of what people are.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Very much. Have a lovely evening.